Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7058. Eli M. Borochov et al., Sherry Mayer Borochov et al., appellants, versus Islamic Republic of Iran and Syrian Arab Republic. Mr. Tolchin for the appellants, Mr. Nell, court-appointed amicus curiae.
Good morning, Your Honors. Excuse the court. It's a pleasure to be here in person.
We agree.
So there's two issues I think to address today. One has to do with the status of the appeal, and the other is the substance of it. Would the court prefer to start with one or the other? Or?
You start where you feel most comfortable, and we'll let you know when we have questions.
All right. So the issue about the final order, I don't have much to add to what was set forth in our reply brief, except for the following, that if the court sees it the way I briefed it, that the order, despite appearances, was technically non-final, and remands it to the court below, it should be done with instructions, so that some explanation, so that there's no confusion in the court below as to why it's coming. It shouldn't just be a one-line order that says it's non-final order, then dismissed. The court below has to know what to do about it. Otherwise, I'm just afraid we'll be back here in short order with the similar arguments.
On the merits, what, if any, legal error do you contend the district court made?
Sure. The basic legal error was leaving the plaintiffs, and I'm starting with the conclusion, but leaving these Israeli plaintiffs bereft of a remedy based on the thought process that we did not present everything that the judge thought one might present in this context. Not every case has every kind of evidence that, or every kind of argument, or every kind of proof that you might theoretically have. It would be nice if we had Israeli court decisions in similar cases.
So I'm trying to find out what error of law. So you're saying that the judge erred by concluding that the quantum of evidence that you presented was not sufficient.
Well, yes, I mean, I would qualify it somewhat.
And don't we review that for clear error? That's the way we review damages.
Well, I don't think that's, this wasn't a damages award. If the judge had said, look, I reviewed the Israeli law experts' assessment of Israeli law, and I reviewed the affidavits of the plaintiffs and heard what their damages was, and I decided that these plaintiffs deserve X dollars. So that would be a damages award that Your Honor would review for clear error. Here, the court didn't do that. I believe this is a de novo review.
What authority do you have for that proposition?
You mean for the proposition that it's de novo as opposed to?
Yes.
It's set forth in our opening brief. Let me find the page reference for you. Now, while I'm finding the page reference, I would also say I don't think it matters whether it's de novo or clear error or any other standard, because I think that I'm looking in the wrong brief.
Well, here's, I guess, not to get to the nub of it, and I know my colleagues have questions, so I'll stop after this. When the district court judge asked you to provide evidence, you had one opportunity. Then they gave you a second opportunity with the show cause. And the issue was, what do you need to prove damages under Israeli law? And he specifically asked for exemplar damages. And you didn't do that. Then you filed a motion for reconsideration, wanting a third bite at the apple, and said, well, we can't really provide exemplar damages because we can't serve Iran and Syria. But that kind of begs the question of, well, you know, are there no cases against the Palestinian Authority, against individuals? There are no wrongful death cases. You say that Israeli law generally provides lesser damages in the U.S., but we don't know what that means. So the district court said, look, it's too late, but even if I consider that, it's not sufficient.
Your Honor.
So I'm having a problem seeing where the error of law is in that.
Okay, so let me back up. First of all, the procedural recitation that Your Honor just gave isn't exactly right. There were no 3 requests from the court below. We filed a motion for a default judgment. There was
there's no request, but that's your opportunity. I mean,
right.
When you put a case on at trial and it's time to rest, and then the court has to decide, the plaintiff doesn't, after there's a directed verdict against them, get to say, oh, but we have more evidence. That's your shot. Right. That's your bite at the apple. That's what I meant.
A motion for a default judgment isn't exactly a trial. I'm sure.
I understand that completely, but my point is that that's your opportunity to present evidence.
So, look, first of all, the idea of presenting similar verdicts from another jurisdiction or verdicts from another jurisdiction in a similar case, that's not an issue of law. What the court did here was not an issue of law. The issue of damages, this is really the main thrust, our main argument in this case is that the judge's job when making a damages determination, you know, he was with us all through liability. We got up to damages. And the judge's job, just like a jury's job at a jury trial, is to hear what the law is, to hear the evidence of damages, hear about the injuries, and make an award. If they're in a jury trial, you would never tell the jury what was awarded in another case. You would never call a witness to say, this is a car accident where somebody lost a leg, and now I'm going to give you a list of jury verdict reports from what other juries awarded in other cases. That would be so forbidden you couldn't even mention it, that there are other cases and what other juries did on other evidence. The judge's job is to hear the law of damages.
But that's exactly what you wanted this judge to do, right? Yes. By showing him other awards in other terrorism cases, awards under federal law.
No. Well,
and that's what's done in these default judgment cases.
No. The first line of argument is that the judge should have heard what categories of damages Israeli law allows in the case like this. And based on hearing what those categories of damages are, you know, lost wages, pain and suffering, loss of salatium, categories of damages, then the court should have looked at the testimony of the plaintiffs to see what they said about their injuries, what they said about their damages, and the court should have made an award. Now, we did go on to say that as a fallback, if you don't, you know, it's how do you do it as a judge? How do you, or as a juror, how do you?
So if I'm understanding you correctly, then it was error for him to require exemplar damages under Israeli.
Exactly. That's 100% error. Exemplar damages are nice to have in this context as guideposts, and that's exactly what.
And what's your best case for why precedent from us or any other jurisdiction as to why that was error? If that's what he required, and that's the error.
You don't have to read beyond this court's decision in Frankel or this court's decision in Hill. You know, in Frankel, it's funny because I was the plaintiff's attorney in Frankel, and in Frankel we were very upset at Judge Collier's damage award. She looked at the evidence, she looked at the testimony, and she awarded to us what we viewed as substantially lower damages than should have been awarded. And we argued that because of that it was wrong, as we saw it, for her to award less than what had become like a standard in these cases under Heiser. And she said, I don't care. I'm the judge. I'm supposed to hear the evidence and make awards that are in this case. And Heiser, she said, is just another district court decision. It's not precedent. And our position was like, well,
And we said that was an error because it wasn't binding.
you said it's not binding. Right. You said it's merely, that's my point. We tried as we could.
We didn't say it's not relevant. We just said it's not binding.
Oh, it's certainly relevant. You know, I should qualify.
We didn't say it couldn't be considered. We just said it's not binding.
That's correct. It's something that could be considered. Now, you don't have to consider it. In fact, Judge Collier disregarded it. And she said, I'm going to make my assessment based on the way I see the evidence. And that's what this court said, that it's a guidepost. It can be consulted, but it's not binding. So there's lots of evidence that you could present in a case. You know, it's nice to have an MRI. It's nice to have fingerprints. It's nice to have DNA evidence, but you don't have DNA evidence in every case. Sometimes you have to go to trial without some kind of evidence that you might have. Here, we did not have Israeli law verdicts of the same kind of case against a sovereign, and that's the answer, Your Honor. It's not a wrongful death case. It's not a case against the Palestinian Authority. It's a case against a sovereign state sponsor of terrorism, which we cite cases in our brief.
Where did the district court say it had to have the exact same type of parties as opposed to just examples in terrorism cases of salatium damages? I mean, your own expert said the Jerusalem District Court, which deals with tort claims based on terrorist actions. So has that court ever issued salatium damages in a terrorism case?
Against a foreign sovereign?
I
No.
didn't ask that. I said,
I don't know the answer to that.
Well, but maybe that was, you know, if you don't have it against, I didn't read the district court's order as saying, I want identical parties or parallel parties. I want examples of how these awards, the salatium damages, are computed and applied. And what kind of amounts are given in Israel? Because this isn't like showing examples in a car accident case. This is a very difficult application of foreign law. And so what I've been baffled all along about is why you didn't have one. I mean, your briefing to us is we don't have it against Syria and Iran. And now you say we don't have it against sovereign governments. But then why you wouldn't go, but here's what we do have in other terrorism cases, here's how it's been done.
And the answer to that, Your Honor, is that in my view, a case against something other than a sovereign government isn't really comparable. And
what has that got to do with the nature of the damages suffered by your clients? Do they suffer less? Excuse me, do they suffer less because the defendant is a sovereign?
They suffer more.
Okay, well, then you can explain that. You go, here's what it is. You could say, here's what it is when it's not a sovereign, and we think it should be more.
Right, but I don't think.
But you didn't do that.
I mean, just to use a crude example, if somebody has a baby that dies of crib death and somebody has a baby that's killed by a gang member in a shootout, one is worse than the other. The damages from one will suffering.
That's not my question. My question is that the judge said, I don't know how this type of award is computed. I don't know what kind of amounts they give and how they go about assessing this very difficult to evaluate thing called, you know, the injuries from salatium, from the pain from loss and witnessing the suffering of a loved one, right? So please tell me what Israeli courts do. And your own expert said there's a court in Jerusalem that's really expert in terrorism tort cases.
I wouldn't say that. They're not.
Well, your expert said that.
No, they're not expert in terrorism court cases. What he said is that they had a case.
Do they?
I mean, they don't have a lot of these cases. That's not what he
said, which deals with most tort claims based on terrorist actions. That's plural.
That's correct, but it's not like there's a million cases over there.
No one asked for a million cases.
So
I think you need to understand that the problem here, one of the problems here is that you read too much into either what you wanted to do and you overread what the district court was asking. And to follow up on Judge Wilkins' opinion here, he asked for information, but you didn't provide it.
What I disagree with you completely, and I think you're making a mistake to view the case this way. The amount that an Israeli court may have awarded in some terrorism case is utterly irrelevant. Under Frankel, it's utterly irrelevant to what this court should award in this case. I
I don't think Frankel said it was irrelevant. I think Frankel said it was a guidepost.
It said it's useful merely as a guidepost.
Correct. And the district court asked for some guideposts.
Which can be disregarded completely.
And the district court asked for some guideposts.
And since
when a district court judge asks for guideposts and information, your response is no?
No, my response is that we did not have, even though the expert says that there's some terrorism cases in Israel, in my view, they're not guideposts because they are not against sovereigns. They're on different facts.
But wouldn't you have to give a district judge some basis to follow you down that reasoning? For example, exemplars of cases, and then the experts saying, but this should not be equated. This guidepost should be subject to a multiplier because fill in the blank. Harm from a foreign sovereign, different from harm from an individual, because, and here's the basis in Israeli law, the foreign sovereign is seen as a more formidable, powerful, well-resourced, and potentially repeat actor. So that's going to change the experience of the injury for the victim or something. So it's, the point is that my sense from reading the record is that the district court found the position of the plaintiffs in this case to be somewhat coy. We're going to give upward pushing information, rely on Heiser, these categories are open to you, and not countervailing guideposts, which might be helpful to take into account. And the timing and the belated acknowledgement that, well, there aren't, for legal reasons, there aren't damages awards against Syria or Iran contributes to that. So there's a sense, I think, not just, this information is the be all and end all, but that the plaintiffs had not been fully cooperative or responsive or timely and candid in the case.
Judge, damages awards are not law.
Well,
not law.
Foreign law is
Not law.
something that the court needs information.
Foreign law, yes. Is this actionable? What are the elements of the tort? What are the categories of damages? What are the considerations or the elements for each category of damages? Can a sibling recover? Can a child recover? Or is there damages for loss of consortium? That's the law.
What if an Israeli statute or court decision said that salatium damages are capped at, $1 million? Isn't that law?
That would be law, but we don't have that fact.
Well, we don't have any facts about the content of Israeli law with respect to calculation of damages.
Respectfully, if you're looking at damages awards, those are not law. Those are results. Those are verdicts.
So they're
law.
reviewed for abuse of discretion. What if the district judge in this case had awarded nominal damages of $1? Would you be before us?
I think so.
A claim of legal error?
I think so, because though the judge has discretion to make a damages award, it has to comport to the facts of the case and to the applicable law. Honestly, just to go back to Frankel, it's water long under the bridge, but that's what the district court kind of did in Frankel. She had a view, and this is what Frankel was on the merits part was reversed on. She had a view that the plaintiffs were basically asking for it because of where they lived and where they sent their child to school. You live near the West Bank, you send your child to school in the West Bank, therefore you should expect to be attacked by terrorists. And that was reversed. But even when it came to the damages award, she saw the plaintiff's damages as diminished by their conduct. But the point is, she took the guideposts and she said, but I'm going to call it the way I see it. And she disregarded the guideposts completely. And in fact, she had another case where she awarded many, many, many times what anyone
Wait,
would
so
have
I'm sorry,
ordered
do you
under.
think her error was that she disregarded the guidepost completely? Is that what you just said?
No,
You just
I mean-
said she disregarded the guidepost
no, I'm just
completely.
pointing out that's what she did.
Was that error? In that
Well,
case?
I'm constrained to say that this court said it wasn't, because we did appeal from it again.
No, we didn't say that. We
No, the
said they
second
weren't
appeal.
binding.
The second appeal, you said it wasn't binding, and she was free to call it the way she saw it based on the evidence. But to get back to Judge Pillard's question about what if the district judge awarded nominal damages, I think that would violate what this court said in Frankel, because a dollar doesn't have any connection to the damages these people suffered. That would be an extreme. The question would be harder. What if he awarded $100,000? Then
Can I ask you a separate question and a prior question about whether we have jurisdiction under the reasoning of the district court in the force case? In other words, there's a question whether in a terrorist attack where nobody dies, does the exception to foreign sovereign immunity even apply? And we've not ruled on that. The district courts in this jurisdiction have come out in different ways, in Cabrera, for example, and in the force decision that you cite in your opening brief, but for a different proposition.
right. I believe, I also represent the plaintiffs in force. I believe that Judge Moss's decision in force is really the right view. I know that he invested a lot of careful time and thought into that issue.
If his view is the right view, then you have no claim.
Well, he awarded money to the injured parties. He didn't like Daniela Parnes because she had no. Oh, wait, I take it back. He's still considering that issue. That issue is still going on. I misspoke. I was confusing with another case. That issue is still sub judice with him. It's been for a long time. I suspect, and I don't know this, I suspect that there's some decision here that he might be waiting for.
I'm looking at the decision I believe you cited, in which Parnas was not at home.
Right.
And he said he'd previously entered a default judgment as to most of the plaintiffs, declined to enter judgment in favor of 6. One has renewed her motion for default judgment, and the court, he says, the court reconsiders and changes its view about whether the waiver of foreign sovereign immunity in 1605A
Right.
regarding terrorism applies to attempted extrajudicial
His
killing.
first view, I agree with. His second view, he changed his mind, and there's a motion pending for further consideration on that, except not for Daniela Parnas, because his ruling about Parnas was that, come on, she wasn't even injured. Like, it's not even.
Right, I'm less interested in the details of the awards to the plaintiffs in that case than the reasoning, which obviously is not binding on us one way or the other.
Right.
But if one were to find it compelling, would that not mean that your clients in this case have no claim, cannot proceed? We lack jurisdiction.
If the law is that an injured but not killed party does not give rise to salation claims, then these plaintiffs would be out of luck. That's not, procedurally, that's not the issue that has been raised in this appeal. It wasn't what was raised by the court below, and it's not really before the court right now.
Jurisdiction is always before this court, and a waiver of sovereign immunity is jurisdictional under the Foreign Sovereign Immunities Act.
For sure, but
So
not
it
without,
is before this court.
but not without briefing, I would argue. That if that's a road that this court wants to go down, notwithstanding that it wasn't raised below and it wasn't.
Well, you're the appellant. It's your obligation to establish our jurisdiction.
Well,
And so what I'm interested in is the waiver of sovereign immunity applies to extrajudicial killing, didn't happen here. Aircraft sabotage didn't happen here. Hostage taking didn't happen here. or the provision of material support or resources for such an act.
The issue is the attempt. The word act includes attempt. An act of
The word act includes attempt? What's your authority for that?
the
Such an act is, and I'm referring back to the list that they just gave.
the courts that have awarded damages to non-killed, just injured salvation claims have relied on the word an act of extrajudicial killing, in the sense that if I take a gun and point it at your honor and shoot, but I miss, that was an act of attempted murder. And it's an act of killing, even though it was not successful.
Well,
That's what Judge Moss said originally.
And then there's the Cabrera decision, which takes different reasoning and uses the material support for as requiring purpose. And
there's that too.
Something I'm not sure that has been established in this case. But I take you to be requesting that if we felt that we needed to answer that question, that you're requesting an opportunity for supplemental briefing?
Absolutely. And I think it would be, very, very wise to do that, because it would wind up being a decision that affects an awful lot of cases.
All right, my colleagues have any more questions? All right, thank you.
Good morning, Your Honors, and may it please the court. My name is Kate Stetson. I am here today in my role as a sponsor of the University of Virginia School of Law Appellate Litigation Clinic. It's my pleasure to introduce Andrew Nell as student counsel, arguing as amicus in support of the district court's judgment.
Welcome, Mr. Nell.
Thank you, Your Honors. May it please the court. I'd like to begin by making two remarks. First, the district court's order was a final judgment granting this court appellate jurisdiction. Second, because appellant's claims arise under Israeli law, the amount and the proper calculation of those damages is necessarily a question of Israeli law. The district court was well within its discretion to request briefing on how to calculate those damages. And when plaintiffs didn't comply with the court's show cause order, there was no obligation to apply Heiser or any other federal damages framework. Now, I think this court's questioning is really getting at the heart of what Judge McFadden was struggling with here, which is how to go about actually calculating these damages under Israeli law. And I think, as Your Honors pointed out, and I point you in the record as well to A563 to 66, as well as A636 to A639, there are multiple Israeli cases awarding salatium damages in terrorism cases. That's all Judge McFadden needed. Some understanding of how an Israeli court faced with these facts would go about calculating an actual dollar figure for these awards. To Your Honor's question earlier about what if the district court had awarded $1, I think that gets to the heart of the problem we have here, is if at the end of the day, Judge McFadden had looked at these facts and said, I think an Israeli court would award you $10 or $10 million, there'd be no way for this court to know if he got the question right without some understanding of how that calculation actually takes place. And that's why in all the cases that are citing in the briefing, the district courts are either defaulting to federal damages or simply awarding nothing. But no district court has found the expert declarations that were used here sufficient to figure out how to calculate damages. They go to what is compensable, but not how that compensation actually takes place.
So, but courts, I mean, it's true even for the claimants who are proceeding, the American citizen plaintiffs, that there's a character of sort of normlessness or out of thin airness about all of these efforts to value, non-numerical suffering. So, and to the extent that it appears that Judge McFadden was entering a zero award, not because he was assessing that as any measure of damages, but really almost as a sanction for noncompliance. And you don't defend it as an appropriate sanction, do you?
Well, I guess I wouldn't characterize it quite as a sanction, Your Honor. I think what Judge McFadden said is this is a part of your burden of proof. And if you can't actually show me what the value is of this claim, then I'm not in a position to award you anything. because anything he would have awarded would have been purely arbitrary.
Just to probe a little bit on that, the plaintiffs did establish through expert testimony categories of, types of harm that are recognized in Israeli law, and through the plaintiff's own testimony, what they suffered, which is, I think you'd have to acknowledge, quite analogous to what they proposed, what they presented on the American plaintiffs. And yes, there's Heiser out there as a guidepost, but with respect to those calculations, I trust that the district court also felt that there was a level of being at sea. And so does it not seem arbitrary to grant zero? I mean, even if he said, well, I understand Israeli awards are much lower, therefore I'm going to grant a tenth of what was granted under the FSIA for the American plaintiffs. I mean, there would have been some thinking about that, but to grant zero, there isn't. I guess I'm pushing back on the notion that there's no evidence on which a judge, if so inclined, could have arrived at some damages.
I guess I have two responses to that, Your Honor. The first is that if they come forward with even a single case, not even in a terrorism case, but just an ordinary Israeli negligence damages case, something to establish some floor for Judge McFadden to work off, I think I would agree it would be abuse of discretion. But when he had nothing to go by, any sort of number, even a tenth, would be purely arbitrary. The second thing I point to is, ordinarily within an ordinary jury trial, whatever verdict the jury reaches is reviewed for abuse of discretion on the back end. But because Judge McFadden was sitting as fact finder, he essentially had to do that check on the front end. And so that's why he needed some understanding of what exemplar awards are under Israeli law, particularly when, from what little evidence was in the record, he knew those damages were lower. It could be the case that even a tenth of what these American plaintiffs did receive in this case would be an abuse of discretion under Israeli law. And that's all the court was seeking, was some sort of guidance for how to go about doing so. And I think it was well within the court's discretion when my friend on the other side chose not to present that evidence for Judge McFadden to then reach the conclusion, well, I'm not in a position to award you anything then.
Except
So the expert declaration that's at, A636 and then the subsequent cases about Israeli damage awards in these types of cases. They give examples where, pecuniary damages have been awarded. They don't give any amounts. The declaration doesn't, but it says courts have awarded. Why shouldn't the district court have said, well, give me the information about what the amounts are here in these cases that your expert discusses? Why shouldn't he have done that before deciding to award nothing? So
I think first off, I'd point your Honor to the court's show cause order where Judge McFadden did expressly request what the amounts were. And so I think he had already requested this information. And in the response to the show cause order, and I point you in the record to A571, where in their response to the short show cause order, they have a section heading damages. And what they say is, in these expert declarations that we've presented to this court, which we've taken from Leibovitz and other cases, those declarations didn't specify what the dollar figures were. And so what we actually want is federal damages instead. And so I think Judge McFadden correctly understood that the issue wasn't that they couldn't get these dollar figures from these expert reports. It's that they understood that federal damages were more favorable, and they made a litigation decision to request those more favorable damages. That was, of course, well within their discretion to make that choice. But once they made that choice, there certainly wasn't an abuse of discretion on Judge McFadden's part to hold them to account for that and to say that federal damages is not the proper measure, having not complied with the court's show cause order to award nothing.
Mr. Nell, you said that had Judge McFadden, in the face of the evidence that was before him, not including number amounts in other cases, had he attempted to award damages figures based on that evidence, it would have been arbitrary. But presumably before the Heiser framework, I mean, it has to start somewhere. Was the court in Heiser that has been subsequently relied on as creating a rubric and some guideposts arbitrary if it was the first to award a number in a particular category?
So I think, even in the very first case decided under the FSIA, there's a certain just baseline understanding that district courts have about what salatium damages look like built up over hundreds of years. And indeed, when courts review for abuse of discretion, what they're doing is analogizing to past cases. But when you're dealing with an issue of foreign law, there isn't that institutional knowledge. So it really is kind of starting from scratch and baseline. And if this information truly didn't exist, that would be one thing. But when the information is readily available, the district court requests that information and plaintiffs choose not to provide it, certainly within the court's discretion to, at that point, say that there is no way for me to come to this figure and therefore the proper remedy is $0.
Go ahead. Oh, so the district court did order one of the plaintiffs' damages for pain and suffering for emotional trauma. And that was Roland Gotan. I'm sorry if I'm not pronouncing that correctly. And he said, well, I'm going to carve out an exception for her because she also had a physical injury. Was the award that he gave to her, to the extent it went beyond physical pain, completely arbitrary because you've said there was no basis for him to make any decision?
Well, no, because what Judge McFadden did there is, and what a lot of other district courts have done is, the district courts are unanimous in finding that these expert declarations simply don't give enough information for how to calculate damages. What some courts have done, and what Judge McFadden did for this one plaintiff, is say, in the interest of justice, that they'll then look to foreign law, and in this case, federal damages. And so he actually used the Heiser framework to come up with
Well, first of all, I mean, the foreign law is district law. So
Correct.
that would have been a mistake. But I want to get back to you. But the only reason he said there's an interest of justice for this particular client is because she also, it was a she, as I recall, also had a physical injury.
Correct, Your Honor.
Why is that not an arbitrary distinction between these, all of the other non-U.S. plaintiffs who had, as he acknowledged repeatedly and found, had suffered the very types of injuries that we put under the category of salatium damages. They had suffered this terrible emotional pain and witnessed, their loved ones' injuries and their pain and suffering and recovery process. And so why is it at all permissible to say, well, because this one also got physically injured, I'm going to do an interest of justice decision for her, and everyone else who I have admitted has suffered, I recognize has suffered. There's no question about the fact of damage here, but I'm going to discard theirs. I'm going to make an arbitrary calculation for this person, in your words, an arbitrary calculation for this person, because they also suffered a physical injury. What possible rational basis is there for that?
Your Honor, I guess I'd say in the first instance, I think it would have been within the discretion of the court to have simply awarded nothing to all of the Israeli plaintiffs. When it comes to the interest of justice, at the end of the day, it's inherently a judgment call by the district court judge. And I certainly think it was within his...
Is it subject to abuse of discretion review?
That would be the correct...
Yes, and so why isn't it an abuse of discretion to single one? What if the district court instead had put all their names in the hat and said, I'm going to draw one out, and for that one, I will follow the Heiser framework? Would that be a violation? Would that be an abuse of discretion?
Yes, Your Honor. I think
Okay.
if the district court had on that purely an arbitrary basis...
Why is it not just as arbitrary to go, well, let me see, oh, here's one who also has a physical injury, so I'm going to treat that one completely differently and apply the law that I've said I can't apply?
Well, I'd say it's well established within the law that physical injuries are more grave than purely emotional injuries.
He wasn't, this was not just for the physical injury. This was a separate award for, that he said, for emotional trauma. And so if he can do it for one, so put aside, he can compensate for the physical injury, but this was also, as he said, for the severe emotional trauma. And I don't have a framework. I'm just going to treat her differently because she had a physical injury. But why is it relevant to her emotional damages? Are emotional damages without a physical injury a lesser category in the law?
I guess what I would say is she had emotional damages plus, Your Honor, which is that she had these...
I understand that's what the district court found. She had plus. And I'm asking you whether that plus, when, as you said, the district court found it had no basis to make a calculation for emotional damages. Made any sense then to go that, but I'm going to find a way of doing it because this person also had already separately compensated physical injuries.
Well, the nature of her emotional damages that was compensated would be the emotional damages from the direct victims plus her own suffering. So even the nature of her emotional suffering, I'd say.
That's not what the district court said. It just said because she has a physical injury, I still don't have any information that I need to make a decision, but because she has a physical injury, I will go ahead and give her additional award that includes emotional harm, even though I can't figure out in any way that's not arbitrary how to calculate emotional harms for any of these plaintiffs here.
Well, so again, Your Honor, so the way he actually came up with a dollar figure, though, was not by looking to Israeli law. It was by looking to federal law.
No, I know, but why? I get all that. My question is, if he found a way in the interest of justice to do it for one of these non-U.S. citizen plaintiffs, or the Israeli plaintiffs, he needed to have a reasoned basis for singling that one out, correct?
Correct, Your Honor.
Right, because of that doesn't work,
Yes.
right? It has to have a reasoned basis. What in the law allows someone to say it's a reasoned basis when I've said I don't have law to apply? I can't make any award for recognized and acknowledged damages over here. I have, as you said, nothing other than an arbitrary basis for doing so. But I can be arbitrary because you also had a physical injury.
Well, I guess what I would say, Your Honor, is Judge McFadden surveyed the case law and he saw that lots of other district courts had, in the interests of justice, simply used federal damages as a gap filler.
So they should have done it for all the Israeli plaintiffs.
Well, but I think what this law that has built up, it's inherently a discretionary choice. And certainly he was under no obligation to do so. And so I think what he says in the first instance, there's no requirement for me to default to federal damages. For this one particular plaintiff, in my judgment, she has suffered greater than all others in this case. And so in my judgment, the interests of justice.
Did he find that her emotional trauma was greater than the other Israeli plaintiff's emotional trauma? Did he find that it was greater?
I guess I'd say it's implicit.
The emotional harm.
No, but I'd say it's implicit in his order for the fact that she, in the first instance, all of them, of course, suffered the same emotional harm from this terrorist attack. So she has that, but she also has her own physical injuries, which of course will manifest as emotional harm to her as well. And so I think the fact that he distinguished her physical injuries is also implicitly saying her emotional suffering as well is greater than all the other plaintiffs here.
It's a little bit piling on, but along the same lines, there are cases in other jurisdictions like the Leibovich case and the Goldberg versus UBS case from the Eastern District of New York, where the courts recognize that Israeli courts are unlikely to award the same amount as a U.S. court, and so they gave awards for emotional distress 40%, 45% of a Heiser type framework, and so I guess the question is if it's feasible, the notion that he had not enough to go on feels unsupported.
So I guess I'd say two things in response, Your Honor. The first is that in a lot of those cases, and we think Leibovich is the one that actually gets this right, that if you are going to default to foreign law, that in this case should actually be the District of Columbia and not federal damages. And so it would still be wrong to be applying federal damages. And the second point I'd say, Your Honor, is I think in the first instance, all these courts recognize that it should be Israeli law controlling the proper measure of damages. Now, some judges, when plaintiffs choose not to come forward with that information, have said, well, I'm going to apply federal damages because I'm so moved. But none of them were ever found that they were compelled to do so. And I'd point, Your Honor, to the Botman case where Judge Lamberth actually made the opposite choice, what Judge McFadden did. What he said there is, if we simply default to federal law all the time as a gap filler, there's a real risk that we're going to create incentives for plaintiffs to obfuscate, as you were alluding to earlier, when the foreign law is unfavorable. I think that's all Judge McFadden was saying here is we can't simply use federal law every single time. Otherwise, plaintiffs will get to pick and choose which elements of which jurisdiction's law they actually want to apply in these cases.
And do you have a position on the force issue, whether there's even jurisdiction in a case in which not only were the plaintiffs not killed, but no other person was killed by the attack?
I don't, Your Honor, and I think I would agree with my friend on the other side that it would be in the interest of this court to have supplemental briefing before it ruled either way on the matter.
Colleagues have no further questions?
Thank you, Your Honor.
Very much. Mr. Tolchin, we'll give you 2 minutes.
Over earlier.
You can have 2 minutes.
Thank you. I would just as to what Your Honor was asking about regarding ROTEM.
And I'm sorry, I mispronounced the name.
No, you said it perfect. It is gender ambiguous. There's male and female ROTEM. I believe this one's a female. But I don't deviate from my basic position that the judge hearing the damages is supposed to assess damages based on the evidence in the case, and that looking at what other courts have done in other cases is I would say, even a dubious guidepost. It's a guidepost. This court has held it's a guidepost. I'll confess I kind of like the guidepost, but you wouldn't do it in
You like some guideposts.
Well, I don't
Which
have a problem.
guideposts you like? You're perfect. You seem perfectly
No,
fine with the Heiser guideposts. You asked the district court to
That's what I
apply
meant.
those.
And the Heiser guidepost wasn't just one case. Heiser surveyed numerous other cases, and those cases, many of them surveyed previous cases, and so it was sort of a synthesis of what had been done in many cases to create a rule of thumb. But what the benefit in that is that everybody who comes before the court is treated equally. No, you don't encounter a situation where one person's suffering is deemed less worthy just because of an accident of citizenship. If this court would come out with or if the district court had come out with a ruling that an American citizen who lost a child gets $1 million, but an Israeli who lost a child gets $100,000, somebody might look at that and say, what kind of justice are we administering here?
But
People
choice of
suffering.
law is always like that.
And
I mean, we have in domestic cases, do we apply Florida law or DC law or New York law? And
It's true.
oftentimes that can be outcome dispositive. You get nothing under one form's law, and you might get a generous reward under a different form.
And I would come back to saying that damages awards, Your Honor, and this is where I think you and I disagree about how we see it. Damages awards, numbers, are not law. That outcome determinative, that law impacting the outcome that Your Honor is referring to, I agree completely. For example, if you have one jurisdiction that follows comparative negligence, another follows contributory negligence. One jurisdiction doesn't allow emotional distress and wrongful death cases, the other jurisdiction does. So you can have the same plane crash, but you have one person from a state where there's no emotional distress for a wrongful death case, or a New Yorker, like where I'm from, where all you get is actual pecuniary loss. New York is crazy. You have a surgeon who dies in a plane crash gets his projected lost earnings as a surgeon, whereas a laborer his family gets only the projected lost earnings of a laborer, even though they both suffered the same because they get nothing for suffering. So the law governing damages, the categories, the elements, what I've been arguing, that it does matter which jurisdiction's law you apply. But once you have gotten to what the law is, now the judge has to assess the damages just based on facts, based on what does the plaintiff say in their declaration, or what do they testify? What do the doctors say?
That kind of brings me back to, we agree that Israeli law governs damages, right? We agree on that?
Yes, with the caveat that courts in the DC district court have said that when they...
We don't care. We're not bound by that. And he's not bound by that.
For sure. But the reasoned position they have taken is that when there is unclarity about what the foreign law is, it's okay to apply the federal law or the foreign law. We don't have to apply the foreign law. Once we've gotten to past liability and to the categories of damages, we can apply a more local law, which
Let me get to the brass tacks, or at least how I see this, and I want to give you an opportunity to explain. Your expert declaration gave examples of terrorism cases in Israel, but no damage amounts. The district court saw that and gave a show cause that said, I want some exemplars. Your response was, don't worry about that. Here's federal law exemplars.
Not exactly.
And that's the way I see the record. But to me, then the nub of the issue is, then was it either clear error or abuse of discretion for the district court to say, look, I wanted you to fill in a gap from your expert declaration. I specifically asked you to do that and you didn't. And I don't think then I have enough to calculate damages under Israeli law. To me, I see that as like the nub of the issue. So accepting that as the correct framing, how is that an abuse of discretion or clear error?
And my answer to that, Your Honor, would be that for the judge to want to know what happened in particular cases, and then I suppose he'd want to know what were the damages claimed, what were the potentially, did these plaintiffs have any set-offs because they got money from collateral sources, or who knows what may have been present in those cases. Maybe a plaintiff in that case had a light injury or a heavy injury that would make it not comparable. For the judge to want to know all that, in other words, asking for a guidepost, and then to base his decision on the absence of a guidepost, I would say is an abuse of discretion, because at bottom, the judge is not supposed to be making his decision based on guideposts. He's supposed to be making his decision based on the evidence in this case. If he has guideposts, which he chooses to look at, in my view, for the purpose of making sure that cases tend to have similar outcomes, that's okay. This court has said it's okay in Frankel, but you don't have that in any other kind of case. Any other kind of personal injury case, where there's any kind of case where the damages are not just based on an invoice and a contract and a receipt or a canceled check, where the court has to determine something amorphous like suffering or pain. The jury or the finder of fact hears the testimony of what happened to the person and applies it to the law, period. There is no guideposts. So yes, the judge asked for a guidepost. We gave him, here's the elements under the Israeli law. We did not give him numbers. Maybe he wanted them. I understand. He was looking to see that. But I didn't feel that there was enough of a range of cases for that to be meaningful. I did not feel that that whatever numbers could be provided would really be would really be relevant, because it's not like here.
But the district court did. So you're essentially asking us to say, well, counsel can make a decision as to what they think is or isn't relevant, and it doesn't matter what the district court thinks is or isn't relevant.
No, I'm saying the district court is wrong to think that that's a sine qua non, that he has to have guideposts. He's not supposed to be making his decision based on other cases. He's supposed to be making his decision based on the facts and law in this case. And it was an abuse of discretion for him to say, I need to have numbers from other cases, and I'm not going to look at what.
Was it an abuse of discretion even to ask for the guideposts? Sounds like that's what you're saying. I want to make sure I understand it.
If it were any other case besides a case that's covered by Frankel, a terrorism case, I would say yes.
I'm asking in this case, was it an abuse of
because
discretion?
of Frankel, it's not an abuse of discretion for him to ask, but
you don't have to answer if you don't think you have appropriate information.
To then not make a decision as to not to make an award of damages based on the absence of those non-binding, unnecessary guideposts is an abuse of discretion. And then, as Your Honor pointed out.
And then just to clarify, I think I heard you just say in response to Judge Wilkins that you did have some numbers, but you didn't think they were relevant or appropriate or
I-
a sufficient mass of data to give to the district court. That's what you
I
just
should
said.
be clear about that because I don't want to leave the wrong impression. I did not have numbers. I did discuss later.
You had numbers that you could have gotten
No,
because
we-
just because your expert said, here's the type of things awarded in this was awarded in X, Y, and Z case. And so you could have gotten the numbers.
In our initial submission, we did not submit our own expert. We relied on experts that were
I
submitted
understand.
in other cases. So I had no communication with those experts about anything. Did have communication with the expert when we moved to re-argue. We talked about it, but there were, and I don't have the conversation going way outside the record. That's why I'm hesitating. But the conversation is more, do we have a body of numbers? Like, can we make a chart? In the Frankel brief, we submitted a chart of all the different cases to show which ones were outliers and which ones were. I said, can we make a chart like this? And he said, no, we don't have enough cases.
But you did have some numbers. You just didn't have it. What was in your judgment enough?
I personally actually never had numbers, but you're asking, could I have asked the expert to give me a list of numbers? I could have, but I would never have submitted them because my contention is that they're not on the facts. They're not comparable.
My colleagues, are there any more questions? No. Thank you very much.
Thank you.
Mr. Nell, you were appointed by this court to brief and argue this case in defense of the judgment below, and the court thanks you for your excellent assistance. The case is submitted.
Case number 22-5262. L'Association des Américains Accidentels et al. Appellants versus United States Department of State et al. Mr. Schreiber for the appellants, Ms. Stapleton for the appellees.
Good morning, Mr. Schreiber.
Okay, good morning, Your Honor. May it please the court. My name is Noam Schreiber, and together with Mark Zell, I represent the plaintiffs. Thank you for allowing me to participate in today's argument remotely. I would like to reserve 3 minutes for rebuttal. Your Honors, before I discuss plaintiff's Fifth Amendment claim, I would like to briefly address the district court ruling that the challenge to the suspension policy was moot or is moot. This challenge is not moot because the government failed to carry its heavy burden of making it absolutely clear that it would not revert back to this policy of suspending or otherwise indefinitely delaying renunciation services with the simple stroke of a pen. This was not a rulemaking process. This was a simple policy that it issued, and it could happen again. And
Are you
during
saying
the
they could just? Are you saying they could just? You said with a stroke of a pen. Wouldn't they have to at least wait for another pandemic?
Yeah. Well, there have to be some circumstances, Your Honor, that would
Some circumstances beyond their control, like a pandemic.
Correct, a pandemic or other global crisis.
Right. Okay.
Yes.
So usually when we invoke the voluntary cessation and we use the stroke of the pen line, that means that return to the prior policy is actually entirely within the control of the defendant here, the government. And I think you just said that they couldn't actually return to the prior policy. It's not within their control at all. It's simply if some other sort of supervening out of their control circumstance, again, whether it's another pandemic or some other international crisis that none of us can foresee. What's your best case that in circumstances like that, we still treat this as a voluntary cessation?
Well, my first comment is that we did never invoke the voluntary cessation exemption. What we did invoke is the capable of repetition yet evading review. But both tests or both exemptions have similar.
Well, how does this evade review? You've got plenty of time. You had plenty of time.
Well, it evades review by the fact that according to the government, the suspension is no longer in place, and therefore it's deemed moot. And evading review is judicial review. So that policy is according to the government is moot. However,
you waited. Am I correct? Almost 2 years after the pandemic. You filed your complaint the end of 2021, correct?
Correct.
Correct about that?
Okay,
so you waited, 20 months after the pandemic started to challenge the suspension. And so we don't normally consider things to be of such a short fuse nature that they are capable of repetition yet evading review when someone waits 19 months to file suit.
Your Honor, the issue is.
You may have good reasons. I'm not saying you didn't have good reasons. I'm just saying usually capable of repetition is really breakneck speed emergency litigation that's still even under that pace couldn't be resolved by the courts.
The plaintiffs did not. This was a last resort issue, and the plaintiffs did not. They're not litigators, and they don't jump to litigate these issues. So yes, it wasn't immediately filed during the pandemic and when the suspension went into effect, but it also wasn't clear at that point what was going on. I mean, plaintiffs had no idea whether they would receive these appointments within a year or less, and therefore that explains the delay. But courts have ruled, including the Supreme Court, that when there is no rulemaking and there's no requirement for heavy rulemaking, and it's rather just a policy decision by the agency, that generally suffices to satisfy the evading review requirement.
But there would be different situation. There would be different circumstances, and the length of the suspension could be different. I mean, this is not a situation like an election or a school year where there's a standardized occurrence, the length of which is, set in some kind of regular process. This is a fluid kind of response to an unknown, a public health crisis of unknown duration. So it seems like it's not an exact fit for the capable of repetition but evading review doctrine. No.
Your Honor, I respectfully don't exactly share the same view. The problem, the issue is that this is not, the suspension, as we briefed, is not over. I mean, the government has claimed it is, but there is still an effective suspension in place.
Let's talk about that. That's a different policy. That's the more decentralized policy, giving discretion to overseas posts to decide when and how to prioritize the resumption of services. And with respect to that, I'm just trying to get a focus on the sort of statement of the right. The right is the right to expatriate, or the right to expatriate and get a certificate from the government, because an individual can expatriate without this interview. Isn't that correct?
Thank you, Your Honor. The individual can expatriate without an interview under 1481 A1, A2, A3, and A4. A5 is quite unique, and the expatriation won't have any effect unless that interview is given. As this court pointed out in Farrell versus Blinken, there's the interview, the oath, the in-person requirement, the actual oath, and the act of expatriation of making that oath are connected. You can't have one without the other. I think the language in Farrell is if somebody expatriates alone in a forest and the State Department isn't there to hear it, did he or she expatriate? And the answer in Farrell was no. So the suspension or temporary suspension, or delay, effectively prevents these U.S. citizens from ridding themselves of their U.S. citizenship. And that can be over a year. The record indicates that most, if not all the plaintiffs, the average wait was over a year to expatriate. And during that time, they were suffering real harm, whether ideological and associational harm, or day-to-day harm in their financial transactions, in their basic.
Did you make a First Amendment claim of ideological and associational harm?
We didn't, in this case, we did not invoke the First Amendment, but we, in our briefing, both here and in the district court, we, to support the claim that the right to expatriate is a fundamental right, we linked the right to the First Amendment as well, Your Honor.
Can I ask you, you used the verb what, it was a long delay and they had to, past tense, wait a long time. You had 11 individual plaintiffs in this case, as well as the association. Can you tell me which of those 11 still has not had the opportunity to start this renunciation process, at least interviews, or actually accomplishing it?
Yes, Your Honor. To the best of my knowledge, 7 out of the 11 plaintiffs have either had an appointment since this litigation was commenced, and or received their certificate of loss of nationality. As for the association,
wait, no, as to the other, you said 7 out of 11. So who are the other 4 and what's their status?
The other 4 or 3, I believe. 1 second.
You just said 7 out of 11. Maybe you meant 8 out of 11?
Perhaps. I'm referring Christopher Lazars. I'm not sure of his status. Mark Lewis and Ann Mislin, to the best of my knowledge, have not yet had an appointment yet.
Have they well, the government said they haven't even contacted a post.
I do not have the information on that, Your
Okay,
Honor.
well, they haven't contacted a post, the delay is on them. Would you be able to follow up with a letter updating us on the status of
Yes, Your Honor.
Christopher Lazars, Ann Mislin, and Mark Lewis?
Yes, Your Honor.
Another one that couldn't see it. I would
may,
like to, yeah, no, just before you finish, to be clear.
I'm sorry.
So we know exactly what the status. There's also another one, I wasn't clear on the record, but maybe you know, was Jeremiah Bornstein. But maybe you know whether he's already.
I will update the court on him as well, Your Honor.
All right. But as to everyone else, they've either already had an interview, they're already well into the process, or have actually renunciated. Is that correct?
Correct, Your Honor.
Okay. Have they all renunciated, or there's some of them still?
I think most of them, I can, when I file the letter, I will give an exact detail of each one, but most of them have received their certificate. Some have only had an appointment.
Okay. And then the other question I had is you asked for the relief you seek in this case is an injunction, sort of a blanket injunction, telling, ordering the government, the State Department, I guess, to direct all of its embassies and consulates to work at a quote, reasonable pace in processing applications under A5 to renunciate. Is that correct? That's the relief you've asked for?
Correct, Your Honor.
Okay, tell me how such global relief could work in this context. For example, what would be a reasonable pace for the embassy in Sudan right now? Is there one reasonable pace, or is it circumstance dependent?
Thank you, Your Honor. What we try to portray in the briefs here is that there is not only a delay, but we put that in the background how the government treats non-immigrant visa services. In that regard, we've seen, and I think the record indicates, and it doesn't appear that the government argues otherwise, that it processes many more non-immigrant visa applications at a much faster rate. That certainly was the case when this lawsuit was filed, and that also appears to be the case as well. So if the question is how to formulate relief, once the government is ordered and instructed that the right to renounce U.S. citizenship is not like any other service, routine service it provides, and especially not like non-immigrant visa services, its priorities will naturally and necessarily change. The government now.
So you're seeking an injunction that uniformly across the entire globe orders embassies to reorder their priorities regardless of individualized conditions in each location?
We're asking that the court declare the status of the right, and based on that status.
Well, you have sought relief also under the APA that doesn't require anybody to declare any status of this right. Okay, so you have sought relief on different alternative grounds here, and of course we try to avoid constitutional rulings where possible. And you have sought this injunctive relief, and I'm just trying to even understand how this is the type of place that would be appropriate for sort of a global rather than individualized or consulate by consulate or embassy by embassy form of relief, right? I mean, surely the same prioritization isn't going to apply for the embassy in Sudan or Ukraine as it might say Canada. And then we need to know if you actually have members who are seeking to renunciate in each of those places and how much delay they're encountering. You know, your complaint says that even before the pandemic, people had to wait, quote, months before they could get an interview. And now you say in your complaint, after the pandemic and after there's been some return to normalized services, for the most part, it varies from consulate to consulate and embassy to embassy, people are having to wait months. So I just am really having trouble understanding how this is the type of case that would be appropriate for any form of global relief as opposed to individualized relief.
Well, I have two comments. One response is that the rise in renunciation services is the global trend at this point, and therefore the future will reasonably, what will happen in the future seems to indicate that there will be the backlog will just increase, and I don't.
Is that what has happened in the last year? Because according to the government's brief, and I didn't see any rebuttal of this in your reply brief, the backlogs have decreased in the last year because they've come out of the pandemic for the most part and been able to catch up.
Correct, Your Honor, but the government
do you deny is that sort of a factual dispute in this case?
I don't know if it's a factual, because this is we're bordering on speculative what's going to happen in the future. However, if the past is indicative of anything, the global trend in renunciation services is on the rise. And I'd like to just point this out in the companion case, in the renunciation fee case, which we've mentioned in the briefs here. In that case, the government has indicated that it intends to decrease the fee, which currently stands at $2,350 as a precondition to renounce, back to its 2010 value of $450. Once that happens, it is reasonable to assume that in all consulates, in all U.S. missions around the globe, the increase in the demand for renunciation services will.
So you want an injunction for them to go faster globally?
Yes, you know,
every embassy and every consulate has to go faster and has to reprioritize, because in the future you anticipate there will be more applications and an increase in backlogs. Is that what I understand?
No, Your Honor. Our complaint is asking for what happened is based on the record before the court, which.
Okay, so that doesn't include any of the stuff you just talked about on the.
No, but if I was
so
trying
on the
to
record
address.
before the court. Sorry, just so on the record before the court, I'm just back to my question where backlogs have decreased, and it is. I mean, do you dispute that there are country by country circumstances and maybe even regions within countries If you're near the Tigray region in Ethiopia, that's going to be very different than being in the capital. That there are circumstances on the ground that affect timing
There are
that would be reasonable.
There are circumstances, and each state has its own, each country has its own circumstances. But the question here is
And even regions within countries have their own circumstances.
The question here is one of how to view this right. I don't think,
No, that's not how to view the right. I'm asking how to view the relief that's sought and whether really a global, whether a global type of global relief that the association is seeking. The individuals want their own processing, but the association wants global relief, and whether that's even tenable in a situation like this.
The relief the
Because
association
that goes to standing. That's why I'm asking all this now. It goes to standing.
the relief the association is asking, Your Honor, stems from how the government, and I apologize for repeating myself, but how the government is treating this right. And,
no, I understand. That's why I mentioned priorities. And I'm just, again, I'm asking.
And I'm sorry.
Okay. No, I'm sorry. And I'll just ask it one more time and then I'll stop so my colleagues can ask questions. But to pin down what I'm trying to get here is, because you as the association are also here as a plaintiff. And you need to show that individualized relief isn't necessary in a case like this. That in fact, a sort of global cross-cutting relief, conjunctive relief is available. And that feels very hard to demonstrate to me in this case, because we can take as a given. And I think that's why you said you only want everyone to go at a reasonable pace in your complaint. You just want an injunction for a reasonable pace. But I don't even know what that means. I don't know how the government would even know what that means if this is actually a unique situation implicating foreign relations and foreign conditions where any relief would have to be tailored at a bare minimum, office by office around the world. And there's 200 or something, if I remember right, 200 or something, or 300 or something, these embassies and consulates around the world. Wouldn't it? I mean, it would have to be tailored, right? You'd have to let it be different priorities in Sudan, in Ukraine, in Haiti, right now than perhaps in other areas. You would agree to that, correct?
I would not want to have the government not be able to tailor or use its discretion per embassy or per U.S. mission. But okay. the relief being sought is not against
the same page there.
I'm sorry?
I think we're on the same page there.
Yes, but yeah, that may be true, Your Honor, but the relief being sought is against the State Department and how it treats this right. And again, and I apologize for repeating myself on this, but once the State Department is told that it must treat this right with the respect it deserves, it will naturally and necessarily need to direct its embassies to reprioritize. And if that requires allocating more services per embassy, per U.S. mission, how the government does that, that's their homework. I can't say how they do that. That's their expertise.
So you want an injunction reordering the priorities and operations, staffing and funding of foreign embassies and consulates?
We want a declaratory judgment declaring that this right.
You want an injunction too? Do you want just a declaratory?
That injunction is not detached from the declaratory relief we're seeking. It can't be seen in some vacuum. The injunction itself relates to the declaratory relief. They're one and the same. And it's once declared and once recognized as a fundamental right, the injunction, the nature and the scope of the injunction will flow from there, Your Honor.
Okay. You guys have questions? And I'm just going to ask one follow-up question. I apologize about in your complaint where you said prior to the pandemic, wait lists would normally normally last months, end quote. Do you know how many months that was?
Not offhand, Your Honor. I can use that in the letter as well if that's necessary.
Right.
I guess my only question for you is that, the district court applied shocks the conscience County of Sacramento. And I think your briefing reflects that Luxburg is probably the right due process analysis for a situation like this.
Yes, Your Honor.
Thank you very much. We'll give you a
Thank you,
couple
Your
minutes for rebuttal. We'll hear from the government now.
Good morning, Your Honor. Pardon me, may it please the court. Anna Stapleton on behalf of the government. In the face of a global pandemic, the Department of State undertook emergency measures to slow the spread of COVID-19 by temporarily suspending non-emergent in-person services at consular posts overseas. That initial suspension is no longer in place and so no longer at issue. Instead, this case is about, as Your Honor stated, states' ability to make its own decisions about how to prioritize multiple high-stakes demands. Posts around the world are actively managing wait lists of individuals seeking to irrevocably relinquish their U.S. citizenship. Those wait lists do not implicate any right protected by the Fifth Amendment Due Process Clause, and they readily satisfy the APA's demands for reasonableness under this court's case law. The district court was therefore correct to rule in the government's favor, and we ask this court to affirm.
There are these other ways to renounce citizenship, but I gather that everybody agrees that this subsection 5 is nonetheless needed by people who want to show, for purposes of banking and taxation and the like, that they've successfully expatriated.
So if I could clarify that, Your Honor. So there are, of course, 7 voluntary acts listed under 1481. That's the section of the INA that governs acts to lose citizenship. A5 is one of them. The first 5 are under the State Department's control. A1 actually does also require an in-person appearance. This court addressed that in Farrell, and here's why. A1 is, of course, relinquishing citizenship by way of naturalization to another country. It's not the case that all naturalization results in loss of U.S. citizenship. It has to be naturalization with the intent to relinquish one's citizenship. The State Department, under its authority as given to it by Congress to regulate under this act, has required an in-person appearance at a consulate for that individual to confirm that their naturalization was done with the intent to relinquish citizenship. So yes, there are multiple ways to give up one's U.S. citizenship. Congress has provided that renunciation before a diplomatic or consular officer is one of those options, and we understand that's the option that these plaintiffs seek to exercise.
Does number 2, taking an oath or making an affirmation or other formal declaration of allegiance to a foreign state, does that also require them to come to it in person?
So I believe my understanding, Your Honor, and I was trying to recall conversations with our State Department colleagues. My understanding is that all 5 of the options that are under the State Department's control require, by means of State Department regulations, an appearance at a consulate to sort of confirm, again, the voluntariness and intent to relinquish citizenship. I would need to double check that before I was certain, Your Honor.
Okay, maybe you could let us also know
I'd be happy to.
about that.
And one of them is, I mean, people could come to the United States and get an appointment. Is there any backlog on that? Anything on that?
Options 6 and 7, Your Honor, and it's number 6 that's making a formal written renunciation in the United States. Those are pursuant to the control of the Attorney General rather than the State Department. I'm not aware whether or not there is a backlog on those options.
And we don't want to encourage 7. That's true.
Correct, Your Honor.
Let's not go down that road. Do you happen to have an update on the status of the individual plaintiffs?
I'm glad you asked, Your Honor. So we have been actively working to get an updated status. Your Honor mentioned the ongoing crisis in Sudan. So the office at State Department headquarters, the Bureau of Consular Affairs, that we would work with to get those updates has been all hands on deck in assisting the emergency evacuation from Sudan. So we do expect to have an update for the court, and I apologize we were not able to get that before today's
Understandable. When the complaint is all about the suspension, given the timing that the complaint was filed. But I take it you have read the complaint, and as the case has evolved, is not just challenging the initial suspension, but also the subsequent policies, sort of returning, setting a framework for returning to our new normal. Is that correct?
That's correct, Your Honor. We understand them to be challenging, or sort of to be bringing two sets of challenges. And I think if you look at the complaint, in those causes of action, it's listed as suspension, and then they call it effective suspension, or the waitlist policy. So yes, at this stage on appeal, we are treating those as two categories of challenges. Of course, we think the challenges to the suspension are moot. The challenges to the ongoing delays, we think are active.
Okay. And do you have any sense of, because they say in their complaint, even before COVID, before all of the suspension, anything, there was wait lists for months, in their words. And now it seems to be 4 months in some places. Whether it's back to normal levels, or so, just don't know at this point.
I'm not aware, Your Honor, of what sort of the average wait list was prior to the pandemic. I think the second Benning declaration gives a good bit of detail about the level of operations, at least as of June of 2022. I could point out, for example, that the consulate in Paris, or excuse me, the embassy in Paris, at that time had come up to providing an average of 4 appointments per week. And Mr. Benning states that prior to the pandemic, it had an average of 2 appointments per week. Of course, there are also changes in demand, so I couldn't speak to whether the sort of current wait list is a longer time period than before. I'd be happy to ask the State Department if they have statistics on the wait prior to the pandemic.
I was, but I want to let my colleagues jump in. You didn't challenge the associational standing in this case. And I'm curious about the third prong, which normally is readily met in injunctive cases, but in reading the materials in this case, at least struck me as a question, and so a standing question, whether in fact this is a situation where non-individualized injunctive relief, categorical relief, is even a possibility, both as a factual matter and as a matter of deference to foreign affairs.
So, Your Honor, we certainly agree that an across-the-board injunction requiring the State Department to sort of prioritize these applications, sort of no matter what else is going on, would not be appropriate. And so, in that sense, we agree that that relief is not available. We have, of course, treated that in our briefing as an issue of the merits rather than as of standing.
Why am I wrong to think about it that way?
I'm not sure that you are, Your Honor. Just out of candor, we haven't discussed it that way in our briefing. I don't think we would object in any way to a decision that said the association lacked standing.
Well, of course, you wouldn't object if you went, but I'm really trying to understand, because usually that phrase means, you're going to have to put individual plaintiffs on to testify about facts or something to get relief or damages relief or something like that. And this is a bit of a different problem where you really would kind of, would it even be appropriate to issue an injunction for embassies for which there are no members seeking renunciation? Is it appropriate? And if each one has to be individually tailored based on whether there's a member and then the ground conditions within that region, country, or maybe portion of country, then it feels to me not like the normal APA injunctive relief, normal associational standing relief, but it's different than we normally encounter when applying that paradigm.
I agree, Your Honor. It would be extraordinarily messy to try to sort out what injunctive relief would look like here, and it would require, delving into the department's priorities, conditions at various locations. There is, Your Honor, I think is asking in part about sort of the number of posts that could potentially come within the scope of that relief. So there is a declaration from the association that's in the record, and it lists, I believe, 8 individuals who are specifically seeking to renounce their citizenship. That's at JA 135 and 36. To my recollection, I believe all of those individuals were seeking to renounce in France. I could be wrong about that, but it's not a wide variety of posts that they're seeking to renounce at. And so I think there is an argument that any relief to the association on the basis of the record here would, in theory, have to be restricted to the posts at which its members are seeking relief. But again,
If it turns out the members that they've listed actually are all done or in process, or them for their own reasons haven't even started the process, which just would not be, they just aren't entitled to any kind of relief, then that's why I was asking about the association, because it seems to me, at least from your briefing, which first raised this issue about the individual plaintiff status, that we may end up, depending on what the letter tells us, having to decide if the association alone has standing.
Yes, Your Honor. So first of all, just so that I'm clear, those 8 members I noted are not named plaintiffs. They are other individuals who are members of the association. As of our last update, and again, we will submit a formal update to the court as soon as we can. As of our last update, there was one of those individuals, his name is, I think, Olivier Vaury. He has an appointment scheduled for November of this year. And so at least as that individual, there's no mootness concern as of present. And so, of course, that would mean the association has, the required one member whose claim is right, but not moot.
So I may not have been paying close enough attention, but with respect to submissions by the parties about the status, insofar as you know it, of the named plaintiffs, it seems for purposes of evaluating, if we need to, separately evaluating the standing of the association, we would also want updates with respect to the status of the persons identified as members who support the standing, who are put forward as supporting the standing of the association.
I think that's correct, Your Honor, and we would plan to provide that as part of our update as well. I should also
Mr. Schreiber will too.
point out that the declaration from the association's president does assert that I think he claims more than 800 individual members who he believes are seeking to renounce. And so even in the event that those 8 individuals had all completed the process, which, as I said, as of this point, they have not, there would at least be a question mark of what to do with that assertion.
There would be a question whether that's adequate factually for us to credit for purposes of association.
Yes.
Standing. I have a slightly different question about under 1481, there are the several different, 1481A, several different grounds. And you in your brief characterize the right that they're asserting as, under the Supreme Court's guidance that we should carefully describe the right at issue. And what I take you to be describing as the right at issue is the ability to complete an assessment interview and take the oath of renunciation within a particular time frame. I'm not sure. I mean, it seems more that they're asking for the ability to renounce citizenship, and that what they're saying impinges on that is the inability to get this documentation. Let me ask you, as a factual matter, if I were, for example, to take an oath or affirmation of formal declaration of allegiance to a foreign state with, voluntary and knowing intent to renounce my citizenship in January, but only succeed in December in getting a certification, would the renunciation be effective as of January? Would the certification from the government as a result of the interview and all of that confirmation, would it recognize the action that I took in January, or would it be effective only as of the time of the issuance?
So the answer is different depending on which of those 5 is acted on. So for A5, which is the renunciation before a diplomatic or consular officer of the United States, what happens is there is the interview, the oath is sworn. Some period of time passes, the certificate of lost nationality is issued. The it's not sort of effective. The loss of nationality is effective at the time that the CLN is issued. However, it is backdated to the date of the renunciation oath. So for sort of plaintiff's purposes, they would not be able to sort of demonstrate or to say that they had lost their citizenship until that certificate is issued, but it's effective backdated to the date of the oath.
So to the extent that it affects the United States is, for example, tax treatment of the individual.
Yes, and there is actually a provision of the tax code, it's, I believe, cited in plaintiff's complaint, actually, that describes this explicitly. There's individuals who have completed expatriation are subject to taxation for sort of the portion of the tax year until the date that they took the oath.
They took the oath.
Yes, and let me clarify, if it's under A5, it's the date that they took the oath. I believe that under A1 through 4, it is actually the date that the CLN, the Certificate of Loss of Nationality is issued, and that's the difference. So my understanding is that the State Department sort of recognizes the date at which point it has confirmed that a person has voluntarily completed an act and with intent to relinquish citizenship under A1 through 4.
The region. Plaintiffs point out, both an argument in their brief, they seem to be most troubled by what I think they would call prioritization of non-immigrant visas over the renunciation process, which I guess then feels like maybe just favoritism of their rights. Do you have a response to that?
I do, Your Honor, and I think the Benning Declaration, and particularly the supplemental Benning Declaration, is very helpful on this point. So particularly at the height of the pandemic, the State Department gave posts clear instructions to prioritize emergency services and mission critical services, to include services that were sort of important to humanitarian needs and to the national interest. So the Benning Declaration discusses the visas that were being issued were visas for humanitarian emergencies, for medical professionals, some of whom were needed to come to the United States, people who were involved in food production, an air and sea crew. I would also add a very important one relevant to the interests of American citizens is family reunification. So non-citizen spouses or family members of American citizens who needed to be able to travel to the United States to be reunited with their American citizen family. That was also a top priority. The other two I would add in, of course, are the evacuation from Afghanistan. There were special provisions for some individuals coming from Afghanistan to the United States. Those were congressionally directed.
But is this still true in 2022 when she did her supplement?
Yeah, so I would
declaration, is it because I'm just trying to understand what is this concern about prioritizing non-immigrant visas over renunciation, even now when there's still wait lists?
So under the framework that has been in place since the fall of 2021, there is an sort of ongoing prioritization of those sort of most important needs. And of course, the other thing is that this varies on a post-by-post basis. So some posts may have more capacity and indeed may have the staff to provide visa services, whereas others do not and would be more focused on providing American citizen services.
Okay, is the volume of non-immigrant visa, I'm also trying to feature sort of ratio.
Yes.
If there's, for every one renunciation, there's 200 non-immigrant visa applications, and the processing time might actually be per capita more equivalent or not, but I just wasn't sure but if they're sort of equivalent amounts, then they're concerned about one seems to get processed faster than the other. Would seem more on point.
So I'm not aware of comprehensive statistics comparing the amount of non-immigrant visas versus those seeking to relinquish citizenship. I think I would also say it's not just the number of individuals, but the process involved in both those sort of processes. of course, on the side of individuals seeking to relinquish citizenship, as we've emphasized in our brief, there are very important constitutional concerns in making sure there are, procedural protections that individuals are not sort of being coerced or being pressured into relinquishing citizenship if they don't really want to or intend to. And so I do think it's not just a one-to-one ratio of sort of how many appointments. It's the time, the staff capacity, the expertise involved in making sure that that procedure is done right.
And when they have to appear before a consular official, is that anybody in the consulate, or is that a certain level of person that might be different than the people processing visas?
It is a certain status, Your Honor. I'm
Okay.
afraid I'm not familiar with the sort of technical details, but it's not just any member of the consular staff.
Okay. The processing visas doesn't require a particular status.
I'm not certain of that, Your Honor. I could ask State Department for more information on that front.
Right. Okay. Oh, you don't have any more questions? All right. Thank you very much. Mr. Schreiber, we'll give you 2 more minutes.
Thank you, Your Honors. Just a couple points. First, with regard to, I'm just going to follow up on Judge Millett's question about nationwide injunctions and the interplay with nationwide injunctions and standing. Here, the association has standing, and even if it's one plaintiff or one member of the association, as my colleague here pointed out, I'll direct the court to JA 148. That member is still waiting, has been waiting for well over a year to receive his appointment. He has been scheduled on in November 15th, 2023. There are at least 800 additional members who either have scheduled appointments or wish to schedule appointments, and I can try to report back to the court on that issue. But just focusing on that one member.
I think we'll be fine just to report on the ones that you've already identified in the record. We don't need to create a new record.
Just that one member, Your Honor, is sufficient for standing and for nationwide injunction. Now here, the nationwide injunction is not directed at each and every consulate. It's directed at the State Department simply to make its renunciation procedures simpler and more efficient. That does not require a case-by-case for every individual U.S. mission around the globe.
Your complaint asks for them to process at a reasonable pace. Quote, reasonable pace, those were your words. And now you're saying you want them to change the process to make it simpler? That's what the injunction would do?
Part of our analysis in the briefing here and below was that the method for processing these services is simply not efficient. Whether it takes too long to for these interviews, or whether they refuse to conduct online renunciation interviews, as it does perhaps with other services that it provides, and the very fact that the record indicates that the government favors and prefers pleasure visas over renunciation services. There's no question about it. And that, Your Honor, cannot stand. If somebody wants to visit the United States for pleasure, that he or she may try, but that should not receive preference over a U.S. citizen wishing to renounce his U.S. citizenship, which, and I don't have to go over this, it's in the briefs, has a historical value, and its importance is unquestioned.
My colleagues have any questions? No. Thank you both very much. The case is submitted.
Thank you, Your Honor.
Case number 22-1019 et al. Eagle County, Colorado petitioner versus Surface Transportation Board and United States of America. Mr. Hunt for the petitioner, Eagle County, Colorado. Ms. Park for the petitioner, Center for Biological Diversity et al. Ms. Millett for the respondent, Surface Transportation Board. Mr. Heminger for the respondent, Fish and Wildlife Services. Mr. Johnson for the respondent interveners, Seven County Infrastructure Coalition et al.
Good morning, Your Honors. On behalf of petitioner Eagle County, Colorado, I'm Nate Hunt. 350,000 barrels crude oil will be transported in 18 miles of trains each day across Colorado and the West under the Uinta Basin Railway Project. Put that in perspective, 350,000 barrels a day equals 14.7 million gallons of oil that will be transferred every day of the year under the project. In approving the project, the Surface Transportation Board failed to evaluate the downline environmental impacts caused by that rail traffic and the cargo it carries. Most notably, the board failed to evaluate the impacts to water resources along the existing Union Pacific line, including the Colorado River, which runs right next to the Union Pacific line for over 200 miles of the downline segment. Substantial evidence in the record demanded that the board take a hard look at the impacts of the Colorado River, other water resources downline, as well as biological resources. The board's own Office of the Environmental Analysis determined that under the railway, it will double the accidents on the existing Union Pacific line. And if the project moves forward, the railway will cause 3 times more accidents on the Union Pacific line than on the proposed Utah line in the Utah study area. And yet the board limited its analysis to water resources to only the new proposed line in the Utah study area. That was arbitrary, particularly when the board and the Office of Environmental Analysis was on notice that there could be potential significant impacts to the Colorado River and other downline resources. Colorado's Department of Public Health and the Environment, the state's top environmental agency, warned the board, the Colorado River, you need to take a hard look at the environmental impacts of this rail traffic on the Colorado River because of its sensitivity, because of its ecosystem, because the state and the West relies on the tourism and recreation on the Colorado River.
I'd like you to address jurisdiction, particularly whether your client is a party aggrieved under the Hobbs Act. I get the aggrieved part, but are you a party within the statutory definition of that term as interpreted by our precedent? And I guess I'll just cut to the chase. I think it's the board's brief at page 76 points out that the county did not submit a reply to the exemption petition. The center did, but the county did not. And given that, should we conclude that the county is not a party aggrieved because it didn't engage as a party in the exemption proceeding?
But the party engaged filing a petition for reconsideration of the board's initial preliminary decision. So it did participate as a party when it filed a petition for reconsideration. But along those lines, although this court, I'm not aware of a decision that this court has addressed this, but the Alaska Survival Ninth Circuit case said that a party does not need to participate necessarily in the proceedings for an exemption under the act simply because of the informal nature of an exemption proceeding. And another related point is that the board at Joint Appendix page 4 in its preliminary decision
in Joint Appendix page 26, the board acknowledged Eagle County as a party implicitly by stating that all comments submitted on the exemption proceeding, as well as on the final EIS and draft EIS under NEPA, those were all are compiled and considered as part of the board's record.
You participated in the EIS.
Absolutely.
Can I ask you, you argue in your brief about the standard for the preliminary exemption decision or conditional exemption decision wasn't met. I'm having trouble understanding at this point where we are now why that matters, because we have a final exemption decision, which would sort of carry with it everything, excuse me, that went before. And it's not even clear to me what you get from a conditional exemption. They can't start building anything. So I'm just not
Precisely.
sure what the harm is in the conditional exemption that you're trying to remedy. And if not, then why do we need to decide whether they appropriately issued a conditional exemption, since everything got wrapped up together? You can talk about the merits of whether they appropriately reconsider things or analyze things properly at that stage, but what does it matter?
It matters in terms of the preliminary decision was incorporated in the final decision.
Mm-hmm.
The reason why the Surface Transportation Board instituted a policy in 2007 in the Alaska Railroad case is because it was trying to prevent putting the thumb on the transportation merits. In other words, prejudging the merits of a project. This is precisely the reason why that policy was enacted, because the board was prevented from conducting a transportation policy analysis based on the entire record.
It was prevented, or just maybe?
It was.
Maybe
the board did not. The board failed.
That's a very different.
Yes,
that's a different argument. That's when you make about the final exemption decision. You can say they did or didn't do a good enough job, but
well, it goes to the merits of the final decision. Because
you could, I mean, even if they hadn't done the conditional exemption, plenty of people will look at an exemption decision and go, and people will disagree one way or the other, but say you didn't analyze X or Y well enough, and nothing about that conditional exemption affects your ability to argue after the board made that final exemption decision that you didn't analyze this as the law required. Whether they did it because they done a preliminary one, or they just didn't do the job right, or, and I'm not saying they did or not, we're just saying for argument purposes.
To be clear, we're challenging the final decision.
Right.
It just incorporated the preliminary decision. And in the final decision, the board said the board did not revisit the transportation merit policies, did not revisit the merits of those, and did not compare those policies with the environmental relevant policies in an even balanced way. And that led to, that's one of the flaws in the final decision. And that was the reason why the board enacted the policy against conditionally granting approval, because the risk of clouding the final decision outweigh any benefits of conditionally granting approval to a project that cannot proceed without a final decision.
Just ask, okay. Just one more thing. So just ask it this way. If we were to decide you were right, that they had improperly done a conditional exemption, but you were wrong about the merits of their final exemption decision. Just assume for these purposes of this question, we thought they had done the right transportation merits analysis and the right balancing. Is there any relief we could afford for them having done, at this stage, for them having done the conditional exemption?
No.
Okay.
We raised that issue because under the Administrative Procedure Act, when an agency goes against its policy, its practices, it needs to provide an adequate explanation. That's just one of the, and so we raised
You just
that.
said there's no remedy we could give for an
Right, but-
improper conditional exemption at this point. And
Right, but you could still consider it as an arbitrary, as an arbitrary measure as part of the overall final decision.
Okay. As part of-
So the interrelationship between NEPA claims, ESA claims, and the Rail Act claims is a little bit unclear to me. So you argue that the NEPA analysis was inadequate for failure to consider the water effects and the fish effects along the Colorado River downstream of the project, right?
Correct.
And I take it you've also argued that the deferral of consideration of the geological hazards violates NEPA. Is that right?
Yes, that's co-petitioner's argument.
Okay.
Yes.
But I also take you to see the various things like the greenhouse gas emissions, which were identified in the environmental analysis, but then not weighed in the rail policy. So is the claim that even if something's adequately surfaced in the NEPA analysis, that the fact that it may be adequate for NEPA purposes doesn't mean that it's been adequately considered in the decision under review? Is that part of the nature of your claim?
Yes, exactly. There are two different statutes with two different processes. NEPA is a procedural statute. Here, the board found significant impacts to water resources and other things. It's our position that they didn't meet the standards for NEPA, but that is a separate decision in the substantive analysis that's required by the Interstate Commerce Commission Termination Act, which is that the board must conduct a substantive analysis of the relevant rail policies. And as part of that analysis, weighing the transportation merits versus the environmental harms.
But there's this whole argument about cumulative versus indirect effects, and the respondents say, they were considered in the same way. It's not entirely clear to me what the argument is about the impropriety of cumulative. I take it that one way of understanding what they did was they said, yeah, we're recognizing these other effects, but only as raising the baseline against which project effects are then evaluated as an additional increment. That would be a very different consideration, but they're also talking about the effects as effects of the project. And so could you just help me understand what's at stake and where it's reflected in the record that they underweighed the effects, for example, climate effects, by treating them as cumulative rather than indirect?
I will, to the extent I acknowledge that that's a claim that co-petitioners are I'm sure, going to want to address.
But you also raised that claim.
No, we have not.
I'm sorry.
But I'm happy to discuss it.
I'm sorry. I'll ask co-petitioners.
Our claims have to do with indirect effects, not how they're categorized.
Not also the improper characterization of effects.
Correct. Our claims focus on water resources. They focus on biological resources. They focus on downline impacts to land use and recreation. And so our claims do not touch upon the distinction between indirect and cumulative impacts.
Focusing on the Interstate Commerce Commission, on the Rail Act, the policies that you say that they didn't consider, you're focusing on health and safety?
They base the decision on 6 rail policy factors. Our position is that their analysis of rail policy factor dealing with enhancement of competition, the rail policy dealing with the improvement of or enhancement of economic conditions in rail were woefully inadequate. The two environmental related rail policy issues that we have claimed they did not adequately consider, especially in the top context of all the rail policies, are the public health and safety rail policy and worker safety. And the board takes a very broad approach to those. Here, the board considered the environmental effects downline, such as wildfires and rail safety under those. But those are the two environmental related rail policies that the board did not address in its preliminary decision. It punted those till the final decision.
And how are they inadequately assessed in the final decision?
Which ones are you?
You just mentioned wildfires. You mentioned two.
Wildfires
Yes.
and accidents, I think.
Yeah, well, I'd also like to address the first two as well. If you
Address them all.
yes, well, I'll address the first one, which is enhancement of competition in rail between conventional rail and other modes of transportation. Board found in the preliminary decision this is going to enhance competition in the region. Page 27, the joint appendix, final decision. Board goes so far as to say nothing in the environmental record makes us question our determination in the initial decision that competition is going to be enhanced. Well, that's flat out rejected by the Office of Environmental Analysis conclusions on what was going to occur if the project is approved. There is the Uinta Basin is capped at 90,000 barrels of oil right now. But for refineries in Salt Lake City cannot handle any more of the oil. They need another way to be able to get the oil out of the basin. Overall trucking, if this project is approved, overall trucking is not going to change. So there's no competition between rail, as the board found and as the coalition argues, there's no competition that's going to be stimulated by this project.
Wouldn't there be price competition? No.
Yeah, exactly. I mean, the board doesn't go into detail on what really the details of how competition.
So, right, I read the record that way too, where they're saying the workers that are in trucking, the capacity in trucking is apart from and would remain, and then the capacity that would be facilitated by the rail is over and above that. But you're saying that their reference, we can't reasonably understand their reference to competition to be kind of price competition, that people will no longer be using those trucks if they could deal more cheaply over the rail?
Exactly. And I'm not just saying that the Office of Environmental Analysis said overall trucking is not going to be reduced. That's joint appendix.
Amount of trucking, but would the price for it go down?
They didn't. The board did not dive into those details. Details that you would think that you would dive into that are conventional, that are related to
Isn't it self-evident isn't it self-evident if suddenly the well owners have a choice about which way to transport? The prices will. Right now, you have to have a monopoly on transportation. I don't mean it in any pejorative sense against the owners of the trucks, but just a sort of world reality monopoly because they're just the road in and out. And now the point is, I think the board's point is that now there'll be two ways in and out with two different resources to be used for transportation, which just inherently increases choice, that increases competition.
That hits precisely the flaw in the competition assumption that the board made. If the Office of Environmental Analysis determined that only 10,000 barrels that are currently being trucked out of the basin are going to be displaced by the rail, that are going to go to the rail. So that's 10,000 out of 90,000 barrels. So when you think about that, it's projected that 350,000 barrels of oil will be transported across the Rocky Mountains. 10,000 of that is going to be replaced, is going to be oil that is now being trucked. So that's the competition. It's 3% of what
If there's 300, if the trucks can only do 90,000 and there's going to be 350,000, then the train is doing the 140,000. Is that math right?
No,
It's the low oil production is projected at 130,000 barrels a day. High oil production is projected at 350,000 barrels a day.
Did you want to talk some about the wildfire risk and the accident risks? So, as you mentioned this, I thought you said those were two of your arguments as well. Am I
You
misdirecting
had
you?
4: competition, wildfire, accidents, and what was the fourth?
There's a rail policy that the board needs to determine whether the project is going to enhance sound or is going to promote sound economic conditions in rail.
And your position on that?
It's baseless. I mean, there's nothing in the record that suggests that this is going to enhance sound economic conditions. There's nothing in the record that they could make a decision on.
It's hard to tell in the context of this case what that even means. I mean, they say no need to examine the financing or not, because that's something the market will take care of, even though Utah says this is not a market project. This is a public infrastructure development project. So presumably the taxpayers are going to pay for it. So what is the theory, as far as you can glean, having been involved with this longer than we have, what promoting sound economic conditions for rail even means in this context?
To be honest, I don't know. I mean, that's one of the flaws in this decision-making process. We heard sound bites. We never heard it. We never heard factual evidence. What we do know is that the one piece of factual information that goes to whether this is financially feasible or viable is the consultant study in 2018, R.L. Banks, which evaluated the feasibility of this project. Now, that was not submitted to the board by the applicant. That was submitted to the board by the co-petitioners and is heavily redacted.
What about, I mean, Alaska Survival, which I recognize is not binding precedent of this court, seems to say, no, whether it's a good idea, whether it's going to be too expensive or the like is just, that's not part of the Surface Transportation Board's decision-making. That's for the policymakers in the market and whoever is going to be on the hook.
Right.
Why shouldn't we, even though it's not binding, follow that same approach here?
That is the default position of the board, that we're going to leave it to the market, right? But
or the state policymakers.
Right. But whereas here, where there is significant questions about the financial feasibility of the project, which were raised by many, many commenters, where there is a significant public interest, where there are going to be landowners who are going to have their homes condemned or who are going to be affected by the actual construction of the railway in Utah.
But those you don't represent any of those.
They're not before this court.
You don't represent any of the people in Utah.
No, I'm going over rationale that the board has provided in the Texas Railroad case, where it justified going away from the default rule that we'll let the market handle it. Where there's significant public opposition, where there's significant questions about the financial feasibility, the board in Texas Railway said, no, there's too many questions. Those questions should be answered in a formal application process where the board is required, and Chairman Oberman, who dissented, really explains this at page 12 of the joint appendix. The board is required to consider the financial viability of the project, the public need for the project, and the public interest. And the reason that the board took that position in Texas Railroad, which we've explained in our brief, is that the board doesn't want to authorize a speculative project, have it be constructed, and have significant environmental impacts, only to have a railway that's not used. Because it's not profitable or because demand is not there. And as Chairman Overman in his dissent, in both dissents highlighted, the applicant, the coalition's own consultant concluded that they don't know how much oil reserves are in the basin, into a basin, and they don't know what the demand is for this particular type of oil, waxy crude oil. So that right there demonstrates some speculative nature.
I think your clients would be nothing but happy if the railway didn't operate, because then it wouldn't be coming into Colorado. This feels like an argument that I would expect someone from Utah to be making, but no one is here. You know, and as far as your interests are concerned, if they build something and it never leaves the station, that's good for your client.
That's a public interest, factor. That's a public interest.
It's not Colorado public. It's not Colorado public interest.
No, I think it's safe to say that the general public doesn't want the federal government to authorize billion-dollar projects that have tremendous environmental impacts.
But those construction impacts are all going to be in Utah. Am I correct?
Yeah, that's not.
I mean, you and your clients wouldn't have standing to. I mean, the general public might very well care about this, but you wouldn't have standing to argue about those environmental impacts or the consequences of a train that's built to go nowhere.
And I'm not. That's not one of our arguments. I'm trying to demonstrate the board's reasoning to deviate from its default policy of relying on market factors. And our argument here is that Texas Railroad is very relevant, and the board should, given the record before the board should require a full application process.
Is the financial concern just construction or also operation, which then could affect sort of safety factors coming into Colorado?
That's not on the record, but I can tell you, I mean, as we're all aware, like operations, if a company doesn't have sufficient resources to operate any type, then there's more likelihood of shortcuts.
There's this issue in the case with respect to your client's interests about the capacity of the project and the SDB in approving this project to include any mitigation down line. Their jurisdiction is over the project itself. They say, we couldn't include mitigation downline. Is there some other transaction or regulatory action that would? I mean, I'm assuming if I'm the owner of the Union Pacific line, before I allow, 9 or 10 100-car long oil trains to go on my track, I would charge them for track upgrades, for the wear and tear. Is there anything else that I'm unaware of that would be a mechanism if the board is correct that there's no ability to attach downline mitigation in this case?
That's outside the record. It's not really addressed. I think a railway operator could make those types of requirements. I think that the point of the mitigation factor is that the board only require mitigation of the proposed railway. And in evaluating weighing the harms of the project versus the transportation merits, the board repeatedly said, these are significant, but our mitigation measures are going to address that. And this flaw in that is that any of the downline environmental impacts are not being mitigated. And this is not an argument that was made in comments, but I'm not aware of why, and this is a question for the board, why the board can't engage in some mitigation measures down
Like
line.
what?
For example, the board relies heavily on emergency response mitigation measures to address wildfires. There's nothing, I'm not aware of any law under the ICCTA or NEPA, the relevant laws here that prevent the board from saying, we've determined that this is going to have significant environmental impacts downline, including wildfires in Colorado. You're required to coordinate with Eagle County and the other affected communities down the line to make sure that they have sufficient emergency response measures for wildfires or for oil spills. Nothing prevents the board from doing that.
Like they're supposed to ask you to have more emergency response measures than Eagle County says, or some county X says, no, we don't have the budget. Have you noticed it's a tough economy and it's also hard to hire people? We have no budget to increase our emergency response. Then what happens?
Under any environmental law, NEPA, Clean Water Act, there's wide discretion in what you require for mitigation measures. And that's including
I'm
requiring,
I'm trying to follow up more concretely on whether they're right, that there's really nothing they can do about downline mitigation because it's an existing rail line. And some of the mitigation is going to involve governmental entities that it has no authority to impose orders onto, does it? I mean, could it order you to increase could the board order Eagle County to increase its emergency
Not that I'm
response?
aware of, but it could order the railway applicant to provide funding for mitigation. But again, we're
to fund Eagle County's fire response?
Yes.
They can do that?
I'm not aware of anything that prevents them, but this is, we're getting away from.
Private entity.
We're not challenging.
No, we're not getting away. I'm really trying to understand.
Okay.
You objected to their argument about their ability to mitigate downline. I'm really trying to understand it. So a private entity can help fund public services?
That's not one of our claims.
Okay.
We're not saying that you failed to mitigate downline.
Okay.
We're saying that when you evaluated the environmental harms of this project, you relied heavily on the 150 or so mitigation measures that the board is requiring. Or none of those measures pertain to downline environmental impacts. And that is a significant flaw in your environmental analysis.
So is your argument, I know, but that argument sounds to me like you should have addressed mitigation efforts downline. That's one argument. If what you're trying to tell me is your argument instead is you can't mitigate downline, and so you should have taken that harm into sort of more urgent account when you were making your decision. Is it?
It's the latter.
Okay.
The board did not consider the fact that none of the mitigation measures, which they relied on so heavily to address the significant environmental impacts of the project, none of those are going to pertain to significant environmental impacts downline.
Okay. Can you ask me one practical question that, again, I wasn't clear from the briefing? What is the difference between, substantively, what is the difference between going through the exemption process and the 10901 formal process? You said, well, they would consider financial viability, but how is it different? How are the two different? What else would come into the record that for a 10901 process, or what would the board do differently through a 10901?
I don't have the regulations before me, but they require just a lot more detailed information on the economics of the project, including.
That's the only difference?
Yes, and also it requires a public notice, but also the standard that the board is required. The board cannot set the financial feasibility of the site. It's required to consider that. The board is also required to consider the public need and the demand for the project, as well as the public interest. Those are requirements that the board must consider in the application process.
If it says we did public need and public interest, you may object to it, but we did that in this decision, then the only delta between the 10901 and the exemption process is sort of a better, more thorough analysis of financial viability. Does one take longer? They take the same amount of time?
I apologize, can't hear you.
Do they take the same amount of time, the 10901 process? And
not aware of the timelines for them.
Okay. You have any other questions?
So just to be clear about the scope of your claim as in contradiction to your fellow petitioners, you're challenging the failure to consider wildfires an accident likelihood, and with respect to the accidents, also effect on water.
Yes.
Yes, and the consideration as such of competition and sound economic conditions for rail. This is basically the 4 points that you wanted to highlight.
Correct. And the other rail policies, public health and safety that are environmentally related.
And that's where you get the wildfires and accidents in through public health and safety.
And the board failed to conduct an adequate or even analysis of those considerations.
So climate is not an issue that you're pressing?
Climate's definitely an issue of this.
I thought it was, but I hadn't heard you say anything about it.
Eagle County is not. That's not one of our claims.
Okay.
Our co-petitioners have brought that. There is one other rail policy, though, that's related to climate, and that is the board's failure to consider the rail policy of promoting energy conservation.
That wasn't raised before the board, was it?
It was raised before the board.
It was. By you?
By Eagle County, yes, in our comments in the draft, on the draft EIS. And the board has argued that somehow the timing of our comments, precludes Eagle County from making that claim. That lacks merit. The board again on Joint Appendix page 1226 in its final decision said
1226? No, 12/2/20.
just 26, page 26 of the Joint Appendix. Board says all comments on the preliminary decision, on the final EIS, they're all incorporated. They're all part of our record. So,
and where should we look for your energy efficiency comment?
It's in our comments on the draft environmental impact statement. And that is, I don't have the precise, but it's around 740 of the Joint Appendix.
All right, thank you very much.
Thank you.
Ms. Park?
Good morning, Your Honors. May it please the court, I'm Wendy Park, representing petitioner conservation groups in our challenge to the board's authorization of the Uinta Basin Railway. This 88-mile-long railway will cut across the Uinta Basin's rugged and mountainous terrain, sending thousands of oil trains to the national rail network annually. Those 2-mile-long oil trains will haul billions of gallons of oil annually along the Colorado River on their way to Gulf Coast refineries. And with this new railway, Uinta Basin drillers will ship, drill, and sell more oil by more than 350,000 barrels per day. And so I'd like to address in my argument today 2 issues. One would be the indirect effects of the project, the board's failure to consider in the EIS the upstream and downstream oil production harms as indirect effects of the project, and why this was prejudicial error, going to Judge Pillard's question regarding both under NEPA and under the ICCTA. And I'd like to also address the biological opinion's failure to consider the effects of oil spills and leaks on the 4 Colorado River endangered fish. So turning first to our claim regarding the indirect effects of the project. First, I'll just provide a little bit of context on what this project is about to eventually get to Judge Pillard's question from earlier. The singular driving purpose of this railway is to ramp up oil production in the Uinta Basin. And the EIS's total failure to acknowledge that driving purpose, the intended effect of this project, was a fundamental flaw in the NEPA analysis.
So as Mr. Hunt alluded to in his argument, this project is about opening up access to the national rail network so that oil drillers can move out of the basin hundreds of thousands of barrels of oil per day. And it's only with that access that these drillers will be able to ship oil to in massive quantities to the national or to other refineries outside the state. And in fact, the only products that will be shipped on the line is oil and fracking sand, which is required for greater to expand oil production in the basin.
And isn't there some tiny little, on those same trains, there might be a car with some merchandise or agricultural?
The EIS does allude to possibly that happening in the future, but there are no foreseeable plans to ship any other goods along the line except for oil and fracking sand. So it's all oil-related shipping.
Is this oil all removed through fracking?
I'm sorry?
Is this oil removed from the Uinta Basin through fracking?
Yes, that's what the fracking sand is for. Yes. So every barrel, the EIS actually acknowledged that every barrel of oil that's shipped on the line, again, up to 350,000 barrels per day, would come from entirely new oil production. And that would mean that Uinta Basin oil production would have to increase by almost 5 times current levels for those volumes to be shipped. But the problem is that the EIS failed to connect the dots and disclose that the railway would induce this quintupling of oil production and cause serious environmental consequences for upstream communities in the Uinta Basin and downstream communities in the Gulf Coast. So, for example, the EIS failed to disclose that this project will spur the drilling of thousands of new oil wells and, as a result, worsen oil pollution in the already smog-choked Uinta Basin and destroy and degrade habitat for sensitive, rare desert plants. It failed to disclose that it will unleash more than 56 million tons of greenhouse gas emissions from both upstream drilling and downstream refining and combustion of oil on the line, or nearly 1% of US emissions.
Doesn't it disclose that? I mean, it's in the record. And so I'm trying to understand that NEPA is a procedural statute. It requires acknowledgement of various effects. I thought the figures that you're referring to about the low or the high estimates are actually figures that came out through the environmental analysis. Is that wrong?
No, that's not wrong. Those figures did come out through the environmental analysis. But the problem is that those increased emissions, those thousands of new oil wells, were attributed as effects of oil drilling projects and not as effects of the railway.
And that's, if they're identified, does the attribution matter only for purposes of the Rail Act or also for purposes of NEPA? Because they're basically saying, these are things that are going to be proximately caused by this expansion making the line, the Uinta Basin connect to the Union Pacific line and be able to bring this oil to the coast.
I absolutely disagree that the EIS says that these oil production harms are approximately caused by the railway. There is nowhere in the EIS that they admit to these effects being caused by the railway. And to get to the other part of your question, Judge Pillard, it matters for purposes of NEPA, not just for purposes of the ICC Termination Act. The whole point of NEPA is to inform decision makers and the public of the environmental consequences of the proposed action. But by masking oil production harms as the effects of other projects in the board's cumulative impacts analysis, the board obscured the railway's causal role in creating those effects. And that is contrary to NEPA's demand for forthright disclosure
Except they
and
said
analysis.
we would reach the same decision, even consider treating them as indirect effects. So they would have processed it both ways. And so they told the public, even if these are indirect effects, that is caused by the railway, our outcome is the same. So what do we do with that?
Your Honor, I disagree that they said that they would reach the same decision. So they assert that post hoc in their briefing that they would have reached the same decision. It's a post hoc rationalization, and it has absolutely no support in their decision or in the record. And so it's footnote 15 of the decision, which is at JA 40 that I think you're referring to. And it says, furthermore, regardless of whether the EIS labeled the impacts from oil and gas development in the basin as indirect or cumulative impacts, OEA conducted a full analysis of those effects. The impacts from the analysis of those impacts would be the same no matter which label is used. And so that does not say that the decision would have done the same. What that says is that their NEPA analysis would have been the same regardless of this so-called, what they call a mislabeling error. But
if the impacts are the same, on what basis do we think it would change so your argument that it would change the ICCTA decision? I don't know how we do that if we say the impacts are the same. It's all analyzed and the impacts are the same. How could we possibly think that it would make a difference under either one?
Well, so what they're not, so the reason why it makes a difference is for purposes of the weighing analysis, which entirely, the weighing analysis between the transportation benefits and the environmental harms of the project, the board entirely relied on the EIS for its accounting of harms.
Is there another EIS process required, for example, if new wells are authorized in the basin?
There possibly could be for new federal oil wells, but the point under Sable Trail, that doesn't matter because here the board had the ability to deny the project on the grounds that the project was too harmful for the environment. And so all of those new oil wells, it doesn't matter if there are other approvals that are further down the line, because the board had the ability to deny the project on the basis that all of those new oil wells could be too harmful for the environment, then it had to consider the effects of those oil wells in its indirect effects analysis. It couldn't simply ignore them. And I think that the problem that's at issue here is that, on the one hand, the board says that they couldn't consider these effects because it wouldn't be useful to their decision making, because under public citizen, they wouldn't have the authority to do anything about these oil production harms. So that's what they say on the one hand. But then on the other hand, they say, well, actually, we did consider them in our cumulative impacts analysis. But then how could they have actually considered them in their final weighing analysis between the environmental harms versus the transportation benefits if they said in the first place that they were not allowed to consider them? So those effects were never weighed as harms of the project.
I do have a little trouble figuring out what people are referring to as cumulative. Is it your understanding that they're saying, well, we're assuming that those things would happen as a result of separate and independent decisions of oil companies, let's say, and we are analyzing the effect of this rail construction and the use of this line against that higher baseline? Is that the analysis that you understand them to be referring to when they refer to a correctly cumulative approach? Or, I mean, I thought cumulative would be, okay, you add, let's say the greenhouse gas effects of the actual construction of this line and the running of the train on the line. And you add on top of that other effects, the running of the trains along the Union Pacific, the, running of refineries and the ultimate combustion of the fuel. And those things all accumulate to make a big effect. And whether you treat that as cumulative or indirect doesn't matter, as long as you see it all as flowing from the project. That's one way of understanding in which seems to support the notion, why does it matter? We looked at it. But I'm trying to understand what the different treatment is that you're accusing them of having engaged in that doesn't fully count.
Well, because in a cumulative impacts analysis, the reason why the board is considering the effects of other projects, it's not to assess the significance of those other projects. It's not to assess the significance of the effects of other projects. It's to assess the significance of the agency's actions effects in context with all of the other types of stressors or burdens that could be acting on the same resource. So the point is for the board to have, or the agency to have, a realistic picture of the environmental impacts of the project and not just simply look at them in a vacuum.
So packed into that label cumulative, in your view, is that they're saying those are not effects caused by this project. They're just part of the context that this project comes to.
And where do they say, where do they say, and therefore those effects will not be factored into our weighing analysis under the ICC? Yeah.
Well,
where do they say that?
Well, they say that they couldn't consider them because it wouldn't have been helpful to their decision making because they didn't have the authority to prevent those effects. They essentially relied.
But that would be true either way. Whether they call them indirect or not, they say this category of effects, there's nothing we can do about. We can't mitigate.
But what they're essentially saying is that they didn't have to consider them.
Where did they say that? If you can, do you have a JA site where they said that?
Well, they're essentially arguing it in, okay, so I would point the court to, I believe it's in the EIS, the final EIS. And JA 1238. And in the middle of that paragraph, the first full paragraph, okay, well, excuse me, going further up, actually, that the first paragraph at the top of the page. So they say that the coalition's proposed rail line is not a proximate cause of oil and gas development in the basin because such development may occur and is already taking place without the proposed rail line.
Okay, but they're just talking here about NEPA.
Right.
And I was asking you, and if I misunderstood your answer to Judge Pillar, tell me, I had understood your argument to be the reason proper characterization under NEPA matters is not so much for NEPA. They've laid everything out. That's really what NEPA is about. It matters because then when they get to weighing transportation merits against environmental harms under the ICCTA, that's when they discount cumulative effects from that weighing. Is that, I thought that's what you said. Did I misunderstand you?
Well, for purposes of NEPA, I don't believe that they fully disclose the harms as the project's effects. They only disclose those oil production harms as the effects of other projects.
Why does that matter for NEPA? As long as it's fully disclosed to the public, if they got the label wrong, but they disclose the relevant environmental information and consequences.
It matters. It matters for purposes of NEPA because, first of all, they significantly underestimated the project's effects. If they are not.
Okay, but that's just a separate objection. They just didn't do the analysis right. That's a separate, it doesn't apply to how they characterize it.
Oh, I believe it does, because if they're saying that they don't have to consider all of the truck trips from all of the traffic generated by the railway between the oil fields and the rail terminals, then they're not counting those truck trips as having been generated by the project. They're counting them as truck trips that were generated by oil and gas drilling. And so they're not being forthright about the amount of traffic that this project could generate. They're underestimating the total impacts. Yes, they did acknowledge it in their cumulative impacts analysis, but that's a separate. The cumulative impacts analysis again.
Does the cumulative impacts analysis affect the weighing under the subsequent weighing that, right? You do the EIS, that's one thing, and then they're supposed to take these environmental consequences and go weigh them against transportation merits. That's what they're supposed to do in their final decision. Does whether they called it in the EIS cumulative or indirect have any effect down when they get to that balancing on how they do the balancing? That's what I thought you were talking about.
Yes, I'm sorry that I didn't directly answer that before. So, I mean, one thing that they say in their briefing is that they could not have considered oil production harms as a factor to weigh against the approval of the project because their duty to enforce the common carrier obligation.
Right, that's their briefing, but where did the board say? Because that's, we don't review briefs, we review the board's decision. And so
Sure,
where did the board say, we're therefore not including that in our weighing analysis?
Well, so I believe it's implicit in the decision because the decision entirely relies on the EIS for the accounting of harms and the harms of the project. And the harms of the project are only the indirect effects of the project. They can't be the harms of other projects.
I know, but it said even if we treat them as indirect effects, this is the board now said, our decision is the same, even treating them as indirect effects.
Well, so if that's the case, if that's what they said, but we don't agree that they actually said that they would have made the same decision. But if that's how the court would interpret that, there's absolutely no reasoning supplied as to why they would have reached the same decision, as to how they would have gotten to that place, because they don't actually weigh the impacts of oil and gas development in addition to the impacts of the construction and the operations of the railway. So how do they even justify that? That's totally absent from the record.
So do you have a position on whether we have jurisdiction to review or what the nature is of our review of the financing or not of the project?
Honestly, it's not something that we focused on in our briefing. So, but I would agree with Eagle County's counsel that under Alaska Survival, there's for informal proceedings, it's good enough for Eagle County petitioners to weigh in at the draft EIS stage to object to the financial feasibility of the project. And those issues were raised by us, by the conservation groups in our reply on the petition.
So on the substance of the environmental issues, did you want to just briefly emphasize the errors that you think are principal problems?
Sure. So
the fish, is it the fish principally?
yes, there's the fish, but I guess one other thing I'd just like to address before we head to that claim is that the reason why this was also prejudicial under NEPA, this mislabeling error was prejudicial under NEPA is because the board lost an opportunity to consider mitigation for indirect effects of the project or for these oil production harms by considering them the effects of other projects instead of this project.
Say
So-
more? Can you be more concrete?
Sure. So with respect, again, to the massive increase in truck traffic that would arise due to the additional drilling generated by the railway, the board could have considered mitigation like requiring the 7-county coalition to.
You mean the massive increase in rail traffic? You said
No.
truck traffic.
No, I'm talking about truck traffic that results from the massive increase in oil production, the trucks that would go between the oil fields and the rail terminals to bring oil over to the railway. All of that they considered as the effects of other projects instead of this project. And so they did not consider any mitigation for that truck traffic, even though without this project, there wouldn't be any truck traffic going between the railway and the oil fields.
Because there would be no induced additional oil
Exactly. And there would be
production. And is there, I think I just asked Mr. Hunt, there's a separate permitting required for creating new oil wells?
Yes, there would be state permits required for oil wells, but again,
And a NEPA analysis or no?
If it were a federal project, perhaps, but not for a project on state or federal land. But again, going back to Sable Trail, it doesn't matter that there are other approvals down the line because the board is required to consider all indirect effects of the project based on its duty to consider the public health and safety under the rail transportation policy, and because it could deny the project on the grounds that the project would be too harmful for the environment. So if it has
is there a,
right.
So you keep saying cumulative effects, that's not part of this project, but the whole point of NEPA is that cumulative effects are a consequence of a project. That's why you have to discuss them in analyzing the environmental consequences of the project. So is there something in NEPA regulation case law that says the action agency is unable to do anything to mitigate cumulative impacts triggered or contributed to by the project?
I don't believe it's that they're not able to do anything about the incremental impact of the action. I mean, that's really the focus of a cumulative impacts analysis, is the incremental impact of the action.
Right, there's going to be more trucks. It's going to be incrementally more trucks. And so there's nothing they can do to mitigate that? That seemed to be your argument, that they can't mitigate it because they're not calling it an indirect
They can't mitigate for, if they're considering the effects as the effects of other projects, then
cumulative effects are effects of this project added on top of other things going on. That's what cumulative effects are, right? You're adding things of this on top of, like what, that maybe it's not by itself, but when mixed together with other things like decisions about developing oil wells, then this is going to, it's the two coming together. The oil well decision is going to create more oil, and our decision about the rail line is going together. Those are going to create a need for trucks to take the oil from the well to the train. And so it is not as though that has nothing to do with this project when it's a cumulative effect. NEPA says that counts as an effect, a type of effect of this project. So, and I had understood your argument, and tell me if I'm wrong, I can very well be misunderstanding this, that the problem is when it's called a cumulative effect, they can't mitigate. For example, they couldn't do something to mitigate the truck traffic or truck pollution between the wells and the railroad.
right, they didn't consider any mitigation.
They didn't consider as a different argument, but that may be just a substantive attack on their consideration, but they could have considered mitigation effects for those cumulative effects as well, correct?
I suppose there could be a way that I think the point is that mitigation goes to the effects caused by the project.
Well,
And
yes,
here
no,
they,
it seems like there's a separate variable, which is even if you accept that the additional trains on the Union Pacific line would be caused by the project, they're saying, you know, that's in another state. We don't have control over, you know, anything from fire response to maintenance on the tracks to speed that the trains travel. It's just beyond our bailiwick. So whether it's indirect or cumulative or otherwise, and that seems like that's independent objection. It may be bolstered slightly by considering it cumulative, because cumulative seems to distance, you know, conceptually distance those effects. But it seems like it's a distinct objection that they're raising. But we can also ask them about authority to mitigate. Maybe they could do more to mitigate the trucking because it's right there in Utah. It's right there in the counties. It's right at the project rail line.
Great. Yeah, I mean, I think that the problem here, though, is that because they essentially said that they had no control over these effects, that they didn't have a duty to consider them as the effects of this project. And then they not only didn't consider mitigation for those effects, but they also didn't weigh them in their weighing analysis of the harms versus the transportation benefits. And that's the problem here, is that their whole decision boiled down to, are the harms of the project, are those heftier than the transportation merits? And if they considered oil and gas harms, not the incremental impact of the project on top of oil and gas harms, but just the oil and gas harms as the effects of other projects, how could they have considered those as effects of the project or in their weighing analysis? It just doesn't make sense. And so, Judge Millett, I just want to make sure that I
think so. Can I ask you something very separate? There is you know, and this goes to the environmental justice community's argument. Wait, I never knew there was such a thing as waxy crude oil till this case, to be clear. So is there something in the record that talks about, does the refining of waxy crude oil, is it done a different way, involve different chemicals or discharges than non-waxy crude oil, or is the environmental justice concern simply that it will increase the amount of refining done in these communities?
It's simply that the refining would increase in those downstream communities. And
right, there's nothing different about refining waxy crude oil. I would have thought like the wax. I just got this vision of wax like clogging up the machine, but maybe not. So.
Right. Well,
you gotta get the wax out, right?
I'm sorry?
You have to get the wax out, I would assume, right?
They would have to heat the tank cars to get the wax out. Yes.
Okay, but that doesn't cause an emissions that's part of your environmental justice community's argument.
Yeah, I guess the way the record just doesn't speak to what the difference between refining waxy crude is and refining other.
Not in the record. Okay.
Right, and so, but that's the entire problem here, is that they just never took a look at how downstream communities would be impacted by increased refining. They just completely ignored it. And they had plenty of information to at least forecast that increased refining could harm air quality throughout the Uinta Basin. The Houston non-attainment ozone area, for example, is in severe non-attainment status, and it has to meet Clean Air Act deadlines by certain federal deadlines, and adding all of this oil downstream to refineries will only make that problem worse and hinder progress in achieving those Clean Air Act standards. So this was a major problem that's throughout the entire EIS, is that they never acknowledged that the project's purpose is to increase production and that these are the effects from the project itself. And so I guess just to then turn to our Endangered Species Act claim, as you were asking about, Judge Pillard. So with respect to that claim, the biological opinion here entirely failed to address the potential for oil spills and train pollution leaks to harm the Colorado River endangered fish. And those are the Colorado pike minnow, the razorback sucker, and humpback chub and bony tail. But the service had plenty of information before it from the EIS showing a strong likelihood of harm from spills and leaks. So with respect to leaks from oil trains, the record reveals that over 3,400 oil trains would make the trip annually between the Uinta Basin and Gulf Coast refineries or further east, and travel along the Colorado River corridor right next to it. That means that every year more than 377,000 rail cars and over 27,000 locomotives could leak diesel, lubricants, grease, and other toxic fuels into the Colorado River or alongside it and run off into those waters. The EIS also predicts that with respect to spills, they'd occur once every 4 years along the Union Pacific line between Cayenne, Utah, and Denver. And over half of that length of the Union Pacific line runs right against the Colorado River. Nearly 3/4 of those spills would likely release 30,000 gallons or more, which is an entire tanker full of oil.
Okay, I think if you want to just take 1 minute and wrap up.
Okay, sure.
Bit over your
Yes.
time here, and we have other people.
Yes, I'm sorry. Okay. So I guess what I'd like to say finally about that is that the Fish and Wildlife Service here tried to rely on the EIS's explanation for not addressing these effects in the EIS, but the biological opinion has to stand on its own as a final agency action. It had the ability to shape the board's decision regarding oil spills and leaks, and because the Fish and Wildlife Service didn't consider spills and leaks in their biological opinion, it could have found, actually, if it had considered those effects, that the project should require minimization measures for those harms, or should include terms and conditions for the implementation of those measures. But that opportunity was lost because it didn't consider those effects in the biological opinion. So it was very crucial for the Fish and Wildlife Service Agency to actually address them. And even if the service could rely on the EIS's conclusions regarding those effects, the EIS just does not add up in its reasoning. I mean, the EIS is clear that these spills will occur, that leaks will occur, and so that harm should have been considered.
Thank you. Thank you very much.
Okay, thank you, Your Honor.
May it please the court, my name is Barbara Millett, and I am here on behalf of Respondent, the Surface Transportation Board. I will start by addressing the environmental impact in the EIS, since that was a prominent focus of the board's attention earlier. And I think that the starting point for the discussion on that is that the board conducted a full and rigorous environmental review, including a complete analysis of both upstream and downstream greenhouse gas emissions. There is nothing that the board could have done with respect to that analysis that it did not do.
What about address the impact on environmental justice communities of the refining of this oil? Or did they do that?
Well, yeah, the analysis itself as to what the emissions would be was complete as it could be. The assessment of impacts of environmental justice on potential environmental justice communities
was something that we simply did not have the information.
You had the information about at least what region this was going to be going to. You didn't know which refinery in particular, but you knew what regions it was most likely to go to, which is good enough for these purposes. We don't require proof beyond a reasonable doubt.
Well,
And those regions were areas where there are environmental justice communities already suffering ill effects from the refining process, and now there's going to be more. So just you told me they considered everything absolutely that could be considered. So where did they do that?
as this court has found in Burkhead and Food and Water Watch in Delaware, impacts when you are not able to identify end use and you're only able to identify general regions for destinations are not reasonably foreseeable. And therefore, by definition, those environmental justice impacts are not reasonably foreseeable.
This is what confused me about the decision, because it seems like things were foreseeable for some parts of the decision and not for other, right? The where this is going, we know where, there was no question that it was going to hook up with the Union Rail Line and go through Colorado and go to, these certain refineries. No one thinks it's going to New York. No one thinks it's going to California. It was Texas or Louisiana refineries. I have that right. It was going to this region. We don't know which refineries. We don't have contracts for that, but we know with some comfort level of knowledge that it is going to a particular refineries in a region. That they said that, correct? The board said that.
Mm-hmm.
Okay,
right.
So they found that it's going to a region, and that region where the refineries all are. No one's arguing they're going to build a new refinery. So where all the refineries are in that region, there are environmental justice communities, correct? Correct?
It depends on there are 31. It's not that the refineries in these regions are all on one street, and therefore they all affect one potential environmental justice community.
It may be more than one community, but the impact, there's going to be, are there refineries in this region that are not surrounded by environmental justice communities?
The air quality status within the, say, for example, the Houston, Port Arthur region are not the same without, and therefore you cannot.
They're not the same what?
They're not the same. If you look at the attainment levels for each of those areas, what is in Houston is different than what is in Port Arthur. And these we are talking about in the Houston area, there are 15 different refineries, and Houston and Port Arthur are almost 100 miles apart. So we are not talking about a single community.
No, I know. I'm not saying it's a single community. All I'm saying is around the Houston refineries, are there environmental justice communities that will be affected if it's refined there?
Again, because we are talking general regions, I do not think that those are the impacts on those environmental justice communities are reasonably foreseeable. The board went over and above.
I'm just asking a fact question. I'm just asking a fact question. And that is, are there environmental justice communities around the Houston refineries?
There is no information in the record on that.
There's no information on the record on that?
Not that I'm aware of, Your Honor.
And Port Arthur refineries aren't surrounded by environmental justice communities either?
Again, there is no information in the record on that. However, I will say that the air quality levels are substantially different in those two areas. So there is not one simple, we could say, if it's going to this region.
It may not be one simple, but they could say if it goes here, it's a consequence. And if it goes to, we think these are the two most likely areas, or 3 or 4. And if it goes here, here's the impact. If it goes there, there's the impact. But we've narrowed it down, geographically as they have here. We're not we have no idea where in the United States this is going.
Well, first, this is an estimate and a prediction based on multiple factors that are subject to change and multiple factors that are outside of our control or prediction for when you're talking as far down the timeline that we're talking that oil is actually going to be at the point where it will be refined.
But Ms. Miller, there's something very striking about the decision in this case, which is that all of the rationale for the project is to enable the exploitation of the oil resources in the Uinta Basin. And it's saying, look, we've got this valuable resource here. It's kind of locked in there. The isolated empire, as Utah puts it, limited capacity to refine in Salt Lake. Let's build this train line that put it onto the Union Pacific, and then it can be put into the economy and sold and used. Now, there's no scenario before the board that would involve only using this in ways that had to do with lubrication and didn't have to do with burning. That's just not this case. The case is, let's get this stuff out of the ground and get it to the world market so it can be combusted and used as fuel. And then, so that's the sort of the development, the financial case. This is a public works. This is allowing Utah to, get at and get tax revenues and royalties from the exploitation of this valuable resource. So that's the transportation equities, right? And then on the other side, it's like, but we have no idea what's going to happen with this. I mean, maybe it's just going to be used to send alfalfa to cattle in Colorado. No, right? That's not the case here. And so it just begs, it's just hard to understand the logic at a really, really basic level of the Surface Transportation Board saying the productivity that's going to be spurred by this project is something that we're relying on. But the environmental effect of that very productivity is unforeseeable.
We didn't say it was unforeseeable. What we said, so we considered those impacts. We did not close our eyes and pretend that no oil was going to be transported on this line, despite the fact that, while that may be the coalition's purpose, what we were being asked to approve, which is all we can approve, is a common carrier line to provide service to the basin. And we openly and repeatedly acknowledged that the primary commodity on this line was going to be oil. And so we absolutely addressed that thoroughly and completely, and as looked at every aspect. If you look at the upstream development analysis, we looked at everything that could possibly create greenhouse gas emissions and calculated what those would be using the very limited information that we had, because none of these projects are even in the planning stages yet for this upstream development. The coalition is going to have no involvement with those, and that was not part of the project that was in front of us. So the idea that we did not acknowledge that the primary commodity, particularly initially, was going to be oil is just not supported by the record. We looked at it.
Well, you say it's going to be used, but you're not attributing it to the project. And I guess, right? Is that right? You're not attributing it to the project?
Well, I think as the court noted earlier, cumulative impacts are impacts from the project. And
well, but am I right in reading the board as having said, in effect, that we treat those things as happening, going to happen in the future? We look at a future scenario in which there are a lot more oil wells, and there are a lot of oil trains shipping along the Union Pacific line. We treat that as the state of affairs, and then we're assessing the incremental contribution to, the cacti and the fishes and the greenhouse gases of the construction and operation of the project line. Is that a correct analysis of what the cumulative effect treatment was?
No, what we did here was we fully analyzed greenhouse gas emissions from construction and operation of the line. And then under the cumulative impact categorization, we looked at all of the greenhouse gas emissions that could conceivably result from upstream oil well development in the basin. We estimated the number of wells that would be needed to produce the oil to meet the low and high production scenarios. We looked at the likely types of wells that would be done. And we looked at what emissions could be caused by both the construction and operation of those wells. We looked at what other facilities, such as terminals and other ancillary facilities that would likely be built in connection with that oil development. And we examined the greenhouse gas emissions from both the construction and operation of those facilities. We looked at the effect of increased truck traffic in the basin carrying oil from the ancillary facilities and the wells to the rail terminals. There is no source of greenhouse gas emissions with respect to that upstream oil development that we did not look at. And in fact, the petition,
And downstream.
Again, we don't have any information on downstream.
Well, there was the high and the low production.
And so we did a full burn analysis, which is the most conservative estimation we could have done, because as we noted, it is very unlikely that none of this oil will displace existing oil and that all of this oil will be refined. So we looked at the upper limit of what greenhouse gas emissions
Right.
be.
I don't think that the petitioners are disputing that, but what the question was not whether you identified it, but how you characterized it. You said we looked at the cumulative effect, the construction and operation of the line.
Mm-hmm.
And then you said you looked at all that can conceivably result from upstream activities, downstream activities. I take it that the paragraph break between those two, that when you talk about all that could conceivably result from upstream and downstream activities, you're treating those not as effects of this project. Is that correct?
No.
It's not correct.
Cumulative impacts are impacts from the project. They are simply, as the regulation states, they are impacts in which third parties are involved, in which there may be intervening actions, or they are not regionally close to the project, but they are impacts. And there is nothing in the regulation, nor I will point out in the board's decision, that says because these are cumulative impacts, we are treating them any differently than indirect impacts. These were all considered.
What was the question the board was trying to answer in approving this project? It wasn't looking at whether it was financially viable. It's clear about that, right? It wasn't looking at whether it was, as an engineering matter, feasible, because it kicked the can down the road on geologic effects. It wasn't looking at whether it was good environmental policy to enable the extraction and exploitation of oil at a time when, to contribute potentially large amounts of greenhouse gases. So what was the checkbox saying, like, this is a great idea, or this is an acceptable idea, or this is permissible under what our remit is looking at?
Well, I think that's an important question. We are a transportation agency, and if you look at the construction statute 10901, there is an affirmative presumption that we shall approve construction applications or exemptions unless it is inconsistent with the public convenience and necessity. And I see I'm out of time.
You can keep going.
Continue. Okay. And so it is in determining, so there's the affirmative presumption that we should be approving.
Yeah.
And that is our starting point, and that is the first question before the agency.
Yeah, keep going.
And so when you look at the exemption process, you look at the RTP factors, those rail transportation policy factors, and you weigh those that are relevant. And that encompasses all of those policies, whether they be competition, whether they be whether they be the sound economic policy or transportation policy.
In what respect is this sound economic policy? I just found myself really unable to understand that. If you're bracketing the notion that that it's going to be financially feasible. That's the problem of the counties, right? If it's out of their pocket, or I mean, you recognize I guess the dissenting commissioner recognized that the market is very soft for this commodity. So, there's no private oil company jumping in to try to pay for this rail line. So when you look at the economics of it, what from the STB perspective, what are they?
Well,
What are
again,
you assessing?
the board does not assess the financial viability of a project. We look at transportation merits in the context of our statutory mandate is to promote rail transportation. And so we have repeatedly said the financial viability of the project is something that we don't look at and is something that will be determined by the markets. Our grant of authority is permissive. So
Right, I understand that. I guess,
Okay.
but you were referring to, and I'm just looking for the statutes. I have it right in front of me. One of the rail transportation policies is economic conditions in transportation. What does that mean?
I think that is a very broad policy type factor as to whether this fosters development of the rail transportation network.
Always building new rails. Always, it feels tautological. Is it more than tautological?
I suspect that in most cases that does support granting it, but again, it is one of 15 factors. And yes, our statutory mandate is to foster development and maintenance of and health of the rail transportation.
And then the one to reduce regulatory barriers to entry.
Correct.
Approving a rail line with very little scrutiny is, again, it feels tautological. Like, let's not regulate, come on in. What was the scrutiny on that factor?
So the question is not, let's reduce regulatory barriers regardless. It is that is one of the factors that we need to consider. And if you look at 10502, again, there is the shall language.
No, I know, I understand that. I understand. I'm trying to understand the factors and kind of, because the order is pretty general and somewhat tautological. And I mean, I love trains, and I appreciate that you have a narrow remit and that we're not doing de novo review by any means. So I'm just trying to get a better appreciation of what you are actually scrutinizing for and what would be a red flag and make you say no. If it's a new rail line, there's not a problem of market power. There's competition, not really on this record, but what are you really trying to sniff out?
Again, it is a weighing of a combination of factors, both the transportation type factors, such as does this foster competition and reducing barriers. And again, the reducing barriers is a mandate that we have received as something we need to consider.
I appreciate that. Yeah, but it's just what would be a project where expedited consideration wouldn't reduce barriers, or where you're saying go ahead without more scrutiny wouldn't reduce.
What it is that it's not necessary, this is not a case in which it's a matter of unnecessary regulatory barriers. So are we going to make them jump through additional hoops that are not going to and file additional papers and answer additional questions that ultimately don't serve a rail transportation policy purpose?
I'll give you an example. How about Texas Central, when you all said there are so many questions about the financial viability of this project, we're denying an exemption, and they're going to have to go through the full 10901 process and then comply with your regulations, which require disclosure. Your 1150.6, it requires extensive financial information disclosure. How is that reconciled with the board statement here that we don't care about the finances?
In that case, it wasn't a matter of you need to tell us where the financing is comes from. That was a case where the estimates as to costs changed over the course of different filings, where there was insufficient explanation, there was contradictory information.
Why does it matter if you don't look at finances? All you're doing is figuring out, do we have a rail line here or not? And if we say yes and they never build it, oh well.
It's not mandatory, it's permissive.
And I think that in Texas Rail, enough of an issue was raised that frankly, we couldn't sort out what some of the important aspects of the project again, because.
What does it take for enough of a financial issue to be raised? Because there's plenty of question marks here that have been raised, and the board noted some of those arguments and then just said, but it doesn't matter to us at all. I mean, when you get this heavily redacted document about financing, and then, you know, just be a question, well, we're going to try this, we're going to try that. Nothing's pinned down. And, you know, the market for waxy crude oil, shall we say, is not piping hot.